Good morning. Mike. Guess what day it is? Hump day. How's everybody doing this morning? If you haven't done so already, please give your girl a like. We're going to get right over to the Pike County Massacre trial. The judge has entered the courtroom. They're going to begin the hearing on video testimony that the media has brought. It has already been, there's been a ruling by a different and higher court. Okay. I wish that I had more details than that, but I don't. So we're a little bit behind because I wasn't sure how notifications would go out this morning. Because I've been live so much and you know how YouTube be. So I'm going to go ahead and add it to the stream and we'll get started right away. Thank you guys all for being here. I appreciate it.
2018 CR 155. The hearing also involves an order of the 4th District Court of Appeals in case number 22 CA 917, that order dated October 25, 2022.
Good morning,
we have
Amelia.
present in court today John Parker and Richard Nash, who are counsel for the defendant. The defendant is not present.
Yes, Judge, I can address that. I discussed this with my client, our client, this morning, and he'll waive his appearance.
Also present is the prosecuting attorney, Rob Junk, and special prosecuting attorneys, Angela Canepa and Andrew Wilson. Present also is Ryan Scheider, special agent with Ohio BCI&I. Also present is John Greiner, attorney, I believe representing, if I leave anyone out or add somebody, Mr. Greiner, let me know, but previously you represented the Cincinnati Enquirer, Sinclair Broadcasting, WLW-TV, WCPO, WXIX, the Soda Valley Guardian, Court TV, and Law and Crime TV.
Correct.
All right. And also present are Mr. Mooney and Mr. Myers, who represent a witness in this case, Edward Jacob Wagner, and Ms. Roberts may be here too. Ms. Roberts is here too. I want to just give a little brief background, and then we need to get into what the issues are before the court here today. The court has been informing each witness prior to the witness taking the witness stand of the witness's right to object to being filmed, videotaped, recorded, or photographed. Based upon my reading and understanding of Supreme Court Rule 12C2, if the witness objects to being any of those things, being filmed, videotaped, recorded, or photographed, then the court has not permitted that to be done. Again, that's pursuant to my reading of Superintendent's Rule 12C2.
Yeah, Amelia, I don't know why he didn't want to be present, but
on
whatever.
September 2nd, a motion filed, motion for media access. Mr. Greiner, representing the news outlets that we mentioned, filed that motion. The court set that for non-oral hearing on September 9th, giving counsel for the state, counsel for the defense, directing them to file a response. Each did file a timely response, each requesting that the motion be denied. There was a supplemental memorandum filed by Mr. Greiner on behalf of the news outlets, and the court issued an order denying the motion by authority of Supreme Court or of Superintendent's Rule 12C2. Now, the court received yesterday a judgment entry in case number 22 CA 917 of the 4th District Court of Appeals, and that contained language, I won't read it all, but it contained this language: effective immediately, the trial court may not restrict public access to the proceedings, including media access and the ability to photograph or record witnesses, unless a hearing is held on the issue and the court finds that, one, there exists a reasonable and substantial basis for believing that public access could harm or endanger the fairness of the adjudication. Two, the potential for harm outweighs the benefits of public access. And three, there are no reasonable alternatives to closure. The case cited as authority for that in the Court of Appeals judgment entry is State XRL Plain Dealer Publishing Company versus Geauga County Court of Common Pleas, 90 Ohio State 3rd, 79. Court has read that. I'm familiar with that case and have read it. That case originated out of a juvenile court closing the courtroom. It basically changed the approach to juvenile law by opening juvenile courts unless a court held a hearing and made those findings closing the court. Now, as counsel's aware, we've had reporters in every day in this case. We haven't closed the courtroom. The court has been following my understanding of the Supreme Court's decision in State XRL National Broadcasting Company versus Court of Common Pleas, 1990 case, 52 Ohio State 3rd, 104, in which the Supreme Court denied a writ of probation, denied a writ of probation that was sought against the judge, asking that the judge not be permitted to enforce an order that a witness may not be photographed if the witness objected thereto. In fact, that court, I believe, in the same case, directed a judge to follow. At that time, the number was the superintendent's number was rule number was 11C2. It's now 12C2. So the court's been following that, and my reading, which I thought was the plain language of Rule 12C2. However, and so we have the order of the Court of Appeals. Now, whether or not this court agrees with the Court of Appeals order, I believe that I'm bound by the Court of Appeals order, unless and until the Court of Appeals decides the merits of the petition and decides something else when it decides the merits of the petition, which it's not done. It's issued an alternative writ, or a court of jurisdiction superior to the Court of Appeals issues another type order, reversing the Court of Appeals. I don't think this court, I don't want to get in a situation of violating the rules of superintendents, 12C2. I'm bound to follow those, but I don't believe that the Court of Appeals would intentionally order me to violate a rule of superintendents. I don't believe that they would intentionally do that. So I have to assume that the Court of Appeals reads into Superintendent's Rule 12C2 a hearing requirement. I have not previously seen it in there. But whether or not I agree with that order, it's an order of a court of jurisdiction superior to this court. I feel that I have to follow that. Well, I think my attorney is on the phone. I need to get her on here, I guess. Hello? Maybe not.
Yeah, Doug, I'm here.
Okay. I was introducing this. I probably should have had you on there earlier. I was just informing the body here that the court intends to follow the order of the Court of Superior Jurisdiction, the Court of Appeals, and have a hearing on the issue of whether or not the present witness is Edward Jacob Wagner, and the court intends to have a hearing on his choice. He's objected to being filmed, videotaped, recorded, or photographed. We're going to have a hearing on it. His attorneys are here. I'm not sure I can expand that to consider the applicability of 12C2 to any other witnesses. I can't anticipate who those witnesses will be. I can't anticipate whether they will decide that they do not object or do object to being filmed, videotaped, recorded, or photographed. And even if they did, or I would guess what they were going to do, I feel like that the circumstances may differ with respect to different witnesses. So I don't know, that's something we need to get into, is where we go from this point forward
I'm so glad you're
with
here.
respect to any other witnesses. But I do intend to have a hearing concerning the present witness, Edward Jacob Wagner. Now, I'm not sure whether that's all there may be other issues, but Mr. Griner, you requested a hearing. I believe you've now indicated you represent the petitioner, and maybe not in that case, but you represent the Soda Valley Guardian, or that's the name of it, Soda Valley Guardian, Mr. Myers.
Yes, Your Honor.
And so I'm going to let you speak and tell me what issues that you would like heard today, in addition to the one I've addressed there.
The other issue, Your Honor, is that the prohibition on coming and going during the proceeding has impacted the ability of the media to cover, particularly when we get into opt-out situations. If someone comes in and opts out, the media here who are present in the room can't get down to the room where it's being streamed, and it does kind of impact their ability to cover. I understand the need for decorum in the courtroom, but I think, again, we need to be thinking about less restrictive means. And I think there certainly could be a way where, perhaps requiring the media to sit in the last row, and if it gets out of hand, but I think that that would be the only other issue, I think, today on the docket.
Oh, all right, I appreciate your input. Let me say, first of all, too, there has been a part of the court's media order, and I want to make sure that it's understood that the court is in applying this rule against filming, videotaping, recording, or photographing of witnesses who object to it. The court hasn't been applying a local order of the court. I've been applying my reading, and it may be determined to have been not a good reading. I don't know. At least the Court of Appeals indicates that it maybe disagrees with that, but my reading of 12C2. So, but we do have a local order, and one thing that was raised was the fact that everyone had to be in the courtroom and seated 15 minutes before a hearing started. I'm informed by my bailiff that that's never been enforced. And I, in fact, at times can see through my cameras here that people have come in moments before the judge assumes the bench. And as long as they're in here when we open court, I'm informed that we haven't excluded anybody. And you've pointed out, the whole purpose of this media decorum order is just to prevent there from being too much activity in the courtroom when we're trying to try a case. I don't want the jury distracted by people coming in, going out, whether it's media or anyone else. I never intended for anybody not to be able to leave the courtroom. I think there was, though, the intention that if they needed to leave the courtroom to get upstairs, they could go, but then not re-enter until we reopen court again. After we have a recess, then they could come back in and have a seat in the courtroom. Now, I don't know if you're requesting more than that or not. Leaving the courtroom is fine. We have people that have biological needs and they need to leave the courtroom. But what we have tried to do is, if they leave the courtroom during a session of a hearing, that they not re-enter the courtroom until we have recessed, and usually they're at least 15-minute recesses, and then we open court again. They can come in during the recess and have a seat in the courtroom again.
Well, I think I'm sorry, I didn't mean to interrupt.
No, that's fine.
Before you finish. I think I may have misspoken. I think that's where we maybe get into an issue that if they've left, they can't get back in, a witness comes in, opts out, now they can't watch it, as I understand it, on the stream. and they're sort of shut out. So I don't know how often that's happened, but I think it has happened on a couple of occasions.
Okay.
And I don't know what, I'm not sure what the answer is to that, to be honest, but it would be nice to, that's a bit of a problem.
The difficulty in not having any rule at all is that if, and I've always thought this way, if we allow one to do it, we have to allow everybody to do it. And then we've got just a flow of people in and out, and in and out, and in and out. We haven't really, I haven't detected, I mean, maybe some of the members of the media feel they've been improperly dealt with, I don't know, but I haven't detected, with one exception, I haven't detected any problems with the media. They've taken, they've been cooperative. They've been here every day. Some of them front row here. A lot of them have been here every single day. And I haven't seen a problem and haven't had one. Now, maybe they've had a problem with us, but they haven't expressed it. I haven't heard many. The thing that you mentioned about sitting in the back row, and if they haven't, it might be the answer to those who have to go downstairs or feel that they need to. Now, the reporting media here, the writing media, sits in the front row. We've provided them with a front row seat so that they can hear and see everything that is possible for the public to hear and see. Sitting in the back row and slipping out. Now, I don't know if you anticipate somebody have to go out, come back in, go back out, come back in.
I don't think that. No, I don't think we're talking about that. I think the problem is if a witness opts out and somebody has been down watching the stream, and of course, there's a prohibition on tweeting from the courtroom, obviously. So in terms of, somebody being in the room watching the streaming, a witness opts out, they're shut out then at that point. If there could at least be, perhaps with an opt-out witness, just a couple of minutes to allow anybody, all they gotta do is come upstairs. If there could just be a pause for a few minutes and let, the media who are down in the stream room come in, I think that would probably solve the problem, I think.
For press only.
Yeah.
That sounds reasonable.
Thank you.
Jason, you can talk that over with the other, but I think that's reasonable. Somebody if they're downstairs, somebody opts out, so the screen gets shut off, then they can come back.
Just for the record.
Say it again.
It's my understanding when they're opting out, Jason gets that information in advance of when they come in here, well in advance of when George is brought down here, well in advance of when the jury's brought up there. So there's more like 10 or 15 minutes notice to the media, and it's not been a problem. I also am not sure why we're talking about this issue. I wasn't notified that this was going to be an issue that was discussed for today's hearing, and the requirements are to be notified and served with that, and then a hearing be scheduled. It's my understanding we're here solely for the recording of witnesses, and we've got the jury coming at 10.
Well, be that as it may, I don't have a problem dealing with that issue. The whole idea, I think, is allowing the press to do their job without disrupting the proceedings. Now, as long as we don't have somebody that that sees the need to be walking in and out and it is distractive to come in late and walk completely to the front. That's distractive, and we have had that a couple of times.
Understand.
But if they're going to sit in the back, slip in, I don't have a problem with that as long as it's media, Jason. And you can bring it to my attention if it happens. I might see it, but I might not. My attention's usually over here. So if you think it's being abused in some way, bring it to my attention. Try to deal with it on an individual basis. All right. So that's that issue. Now, the hearing on the witness. I'm going to deal with this. I'm not sure. I'll listen to what anybody else has to argue, but I don't think that I want to get into a blanket order involving each, And I'm interested in somebody explaining to me how this should work if we have a witness opt out, so to speak, to use the term that's been used in some of the filings. What kind of what does the hearing look like? Who do we notify? Where do we have the hearing? That kind of thing. That's to me, I'm trying to wrap my mind around how we're going to have a trial and have multiple hearings on witnesses who don't wish to be videotaped, et cetera. I don't know. My experience has not included that.
Nor mine, Your Honor. Nor mine. You know, I think that ideally there'd be some notice. Obviously, if a person opts in, there's no need for a hearing. So I think that, you know, one would hope that the prosecution, and I don't know what the defense will be doing in terms of presentation of evidence, but that there'd be at least a little bit of notice that a witness who's scheduled would prefer to opt out. I think that if there could be some announcement of that, and then I think it would be incumbent on if someone from the public or if someone representing the media wants to object. And I don't think that in every case there would be an objection. I mean, I think, for example, if there's or something like that, I don't foresee any kind of objection in that circumstance. I think, you know, there's great interest in the trial. That's obvious from the presence of the public here, and there's more interest in certain witnesses than in others. So I think in many cases, if a relatively minor witness chooses to opt out, or if again someone who's undercover, you know, has a need to protect identity, I don't see any reasonable person trying to object to that. If there is an objection, you know, I think the court would have to somehow accommodate some sort of hearing on that. And, you know, again, given travel concerns, if interested parties could, you know, participate by telephone, you know, I think the hearing could take place fairly expeditiously. I understand. I mean, I've tried cases, so I understand what these lawyers are going through. It's an arduous and, you know, it's a tough experience, and, you know, we're not their chief concern, or should we be? But, you know, the public access is an important concern for this court, and there has to be some sort of accommodation, but I think it could be done relatively expeditiously. And I think, you know, again, if there's some ability to use telephone, then I think it wouldn't have to necessarily delay the trial to an inordinate degree. So I appreciate the need to move this forward as well.
Yeah, I appreciate your input. But if the witness opts out, as you put it, objects to being filmed, photographed, videotaped, and recorded, the way I'm reading this paragraph is, I must have a hearing. I don't know who could say we waive our hearing. I mean, I don't know if you could say that for the Press International, or whether.
No, I can't, Your Honor. But I mean, I suppose that you know, the interested press is present, and I would, you know, I guess I could foresee the witness wishing to not be recorded. You're giving that witness an opportunity to explain why. You're giving an opportunity to anybody who feels otherwise a chance to be heard, and then you make your decision. I mean, I think, you know, and again, my problem is just a 2-hour travel time. But again, if there's some ability, you know, and I think I'll be alerted at least on behalf of the interested press, you know, and I'll do my best to be available, and I've got a colleague who can cover for me if I'm not available. So, you know, that's how I would see it going. And it may, you know, again, it may not come up that often.
All right. I do intend to have a hearing today on Mr. Wagner. he's indicated he does object, and I'm going to let his attorney speak for him here in a moment or two, if they're willing to do that. But let's hear maybe from the state just generally about what we're talking about what are we going to do going forward? One of the problems we've had, of course, as the state defense has mentioned it a few times, is that we don't know who the witnesses are sometimes before the day they're called. So, I mean, when we don't know, you know, but nobody else knows. And so that's going to make it difficult to determine whether a person opts out or opts in unless we're aware. I don't know if there's a reason for that, a necessity for it, I guess is what I'm trying to say. In all cases, that we not know the witness before the state calls them. I'm not going to tell you how to try the case, but it just makes, you can understand, it makes it harder for us to have any notice to get a hearing if we don't know who the person is.
Roger, just in general, I guess, actually, the court needs to seek clarification from the District Court of Appeals, because there is nothing instructive in that order that suggests who should be involved in the hearing. It doesn't even say that the media needs to be notified of the hearing or be involved in the hearing. Some of the cases they rely on says that the court, after hearing evidence and making certain findings, I mean, you don't need anybody else present to hear that evidence and make that finding. So, you know, again, the idea that, you know, the media becomes involved in every witness that either the state or the defense calls. Obviously, who we're going to call changes when we have 4-hour delays calls like this. So, you know, but we do have the system in process where your bailiff asks the witnesses. You know, obviously, we agree with the court that the controlling authority is the rules of superintendent in this matter, and I think the court has been applying it appropriately, and there's nowhere that it's suggested that we have a hearing in that situation. I certainly don't object if we have a hearing necessarily, again, as regarding to Jake Wagner, although the court did, you know, hear arguments and written arguments and made a decision on Jake Wagner and Angela Wagner specifically back in September. So, you know, I would, you know, suggest seeking clarifying order from the District Court of Appeals, because there's nothing in there to tell us how to go forward.
And we may get that at some point. We did have a hearing. It was non-oral, but we did have a hearing before on Jacob Wagner and Angela Wagner, but I didn't make these findings. And the reason I didn't make these findings is because my best reading of what I felt was required of me by the superintendent's Rule 12C. But regardless of whether I feel that way today or not, I'm being directed by a court of superior jurisdiction to do this. I frankly don't want to violate the rules of superintendents, nor do I want to violate an order of the 4th District Court of Appeals. I'm comparing this to a situation where I have made some kind of an order that somebody do something and I'm reversed by the Court of Appeals. I can't then enforce the order that I make them do something, whether I agree with it or not, if I've been reversed by the Court of Appeals. The Court of Appeals has issued this order. It may not be their final order, but it's in effect right now. It says it is. And so I feel like I need to follow it until I'm advised otherwise by that court or court of superior jurisdiction to that court. So that would be the court's position on that. On behalf of the defendant, do you wish to make some kind of an argument concerning the issues that we've got here?
Thank you, Judge. You know, our concern is the fairness of the trials of Mr.
I
Wagner.
understand that. That's my main concern too.
And we have stated our position previously in the memorandum we direct justice file, the various laws and facts. Now, this was a process that was agreed to by the parties, put into writing, the court agreed with it, and now it's come up again. It seems like the media just wants to record certain witnesses and not others, but they've never been denied access to any of the witnesses. And we believe we should continue to follow Rule 12 as you outlined, because that's what we agreed to, and the rule is very clear. And, We think the court has great discretion in how it runs its courtroom, and it's been running it fairly so far. And it would be a real burden on a witness to have to explain in the court why they object. I don't think there are reasons why, or it could be relevant, or they may not be relevant. But they have that right anyway. And to require witnesses, especially a lady, to explain why they don't want to be recorded, is an unnecessary burden that the group is not having.
Well, the next time we have, by the time we have any other witness who may object, maybe we can have some clarification from the Court of Appeals. But right now, taking in everything that I can take in, I have to assume the Court of Appeals is familiar with 12C2, and that the Court of Appeals feels there's a hearing requirement in there somewhere. And that's their interpretation of it, and their interpretation trumps my interpretation. So that's where we are. Now, on behalf of the witness who we have before the court now, he's not in the courtroom now, of course, but his counsel is here. You wish to make an argument as to these three factors, and you've seen a copy of the.
I have, Your Honor.
All right.
Yes, on behalf of Mr. Wagner, I want to acknowledge first for this record that I feel confident representing Jake's interests as he initially expressed them when he signed off on this court's routine form, exercising his 12C2 right, not to be either video or audio recorded. But I lay that down as the predicate because as a function of this court's ruling late in the end of the court day on Monday, we have since that moment in time have had no contact with Jake Wagner, which I'm not complaining about it, but I think it's important to put it in the record. I certainly, based on what Jake has said to us regarding his exercise of that right, have no reason to think he's thought Jake's mind differently. Indeed, indicated the record, we were aware almost a week before he took the stand that would be his position because we talked to him about it in the Franklin County Jail. So we would support the fundamental position that 12C2 trumps the appellate court's order. That said, we're extremely deferential to and fully recognize this court's explanation of the predicament, if I can use that word. You have a superior court who's relying on a Supreme Court decision that regarded juvenile court proceedings fundamentally different, that regarded the complete closure of those proceedings fundamentally different. But they still put the order down. So on behalf of Mr. Wagner, if indeed, as this court has just now said a few times this morning, the court wants to proceed pace with some sort of evidentiary hearing, we would ask first for a modification of the court's late afternoon order of October 24th, permit us to have some brief contact with Mr. Wagner solely on the scope of this issue. This issue being what? The obvious issue is the court's order going to change? Is Jake going to now, from henceforth, to finish his testimony, going to be recorded and broadcast? We would like for a few minutes to interact with him. I think it won't take long because, as I just said, I think I know the answer to that question. And then if needed, we'll put him on the stand as if though it's a suppression hearing for the very, very limited purpose of expressing his ongoing desire to maintain his 12C2 rights and a brief explanation as to why. I have had the chance in chambers yesterday on the record with this court and all other counsel for the two parties present to express a couple of foundational reasons as to why Mr. Wagner wants to exercise 12C2. Some of those, I believe, are common sense knowledge to all of us involved, broadly stated in the criminal justice system as relates to safety issues of inmates incarcerated after they have cooperated as state witnesses, especially when that cooperation includes testifying against co-defendants And then in this unique situation, when it includes testifying against family member co-defendants, we have contended, at least in oral argument on the record yesterday, that portends in safety issues and imperils safety issues, and that common sense teaches us that even though when and if Jake Wagner's underlying plea negotiation is perfected with a final sentencing order, and he goes into prison for the rest of his natural-born days, there will be those in that prison system who will obviously be aware of the situation. But those aware will be far fewer, we say almost as a matter of judicial notice, than if his recorded broadcast testimony is in perpetuity available on the internet. I think we also all know, generally, those of us involved in the criminal justice system, that this isn't just Myers talk. I know, I can represent, and I think I'm not the only one in the room who knows, when an inmate enters the Department of Rehabilitation and Corrections and is classified for a parent institution, among the variables that control classification are the notoriety of the case, the severity of the case, and any other situations that may raise safety concerns regarding that individual inmate. Therefore, in addition, if this court proceeds with an evidentiary hearing, in addition to adducing some evidence from Mr. Wagner, if all counsel present on this media issue are not prepared to join in a stipulation that roughly tracks these matters I've just outlined, then we would ask the court call as a witness one of the DRC security staff members who are conveying George Wagner, the fourth, back and forth. And I would anticipate that anyone in the DRC system, especially the security staff coming back and forth with Mr. Wagner daily from, I guess, the Scioto County Jail, they can say under oath what I have just outlined regards the potential additional peril that could be posed to Mr. Jake Wagner's safety in the future if his testimony is broadcast.
Do you feel that there's a possibility that
That is absolute
his
poppycock.
knowledge of that or his belief of that danger may affect
Absolute
his
poppycock.
openness and
Everybody
willingness to
that
I
testify truthfully?
mean, to state the
Jake
obvious,
already
his
took a
behalf,
plea
because I
deal a
wanted
long time ago.
fulfill the conditions.
The
that I'm
plea
very
deal
sure
was
in nature,
broadcast.
well, yes.
The
Yes, I think it could,
charges,
in
the
a fancy legal
counts,
phrase,
the
rattle the chain.
special circumstances,
needlessly,
all read aloud in
make me
open
more nervous.
court for the
I don't
record
think
and
any man
documented.
can
It's
shake
on the
Jake's
internet
desire to
in
tell the
perpetuity,
truth,
as
but
this
we all
attorney has
know
explained.
the pressures of being
And the
under
fact
oath
of the
on that
matter
witness stand
is
for anybody are significant.
Jake,
And to the extent those
who is
pressures
Jake worried about?
are enhanced,
Other prisoners or his
I think
dad?
that
That's
could
what I want to know.
be a problem, not only for Jake, but for the parties involved who have to contend with his testimony from their respective positions.
Yeah, can I make a point as well? With the spot that we're at in Jake's testimony, I think from a fundamental fairness point of view, the defense has had a chance to cross him. And now if we change the context in which he's testifying by allowing him to be recorded, does that somehow affect the fairness of their ability to cross-examine with what Mr. Myers would just said, any potential chilling or anything like that? So at least with respect to this witness,
Hey,
I would be
Far Away Eyes.
hesitant.
Good to see
Looking at the
you.
big picture of fairness for all parties.
The truth of the matter is,
What we've been doing going forward, we can look at each witness and we go forward, but again.
as far as
I think that
high-profile,
all of those
cases
issues that
go.
Mr. Myers has stated with respect to.
this isn't all that
chilling
high-profile.
effect and
really.
potential,
I mean, it's known, but it's not. Look at how many of you guys didn't know about this case until I started covering it. It ain't that high profile.
We don't even want to take that chance.
Okay.
We don't even want to make that an issue.
It is what it is. And the truth of the matter
So you're
is,
indicating that you feel that then
Jake's
there's,
charges are what they are.
that
And
changing the rule
his
here with
plea
Mr. Wagner, allowing
what it is.
videotaping, recording,
and
photographing, filming.
if an inmate
There's a reasonable
wanted to get a
possibility
hold
affect
of
the
it, I
fairness
mean,
of this proceeding.
they're limited in what they can get a hold of in prison.
I don't think we should
So
inject
this would
something
have
into
to
the
be,
record with
this would
respect to
be
this
like,
trial.
what
we're here
he's
to do.
arguing really is what Jake's lawyer is arguing is somewhere down the line, there may be a person out there in the world who commits a crime and then ends up getting locked up with one Edward Jacob Wagner, and then finds out realizes who he's in there with, and that puts him at risk. That's poppycock. Sorry.
Talking about a witness who's already been on the stand for a day and a half or whatever it's been, but just any defendant who is testifying against a co-defendant. Do you agree with Mr. Myers that may affect?
So I've been a prosecutor I was in the prosecutor's office for 16 years, I was elected prosecutor for 8 years. Whenever you have a cooperating defendant or a cooperating witness, the security issues with respect to that witness are definitely heightened. Now, I work for the governor's office. I work directly with the Department of Rehabilitation and Corrections from a policy issue. I know firsthand the security issues that come with cooperating witnesses and what can happen to them, how they're viewed by other inmates, the security risk that goes with that. What Mr. Myers is saying, again, is generally and well known by all participants of the criminal justice system. Because of my unique position with the governor's office and with DRC, again, I get to see at the strategic level how that plays out. So yes, I have actually called DRC headquarters this morning to talk about this issue with them. And I've had the opportunity to talk to some of the STAR team members this morning. And it's without dispute that witnesses, co-defendants who testify against their other co-defendants, there is a risk to those co-defendants. And Mr. Neff and I were talking this morning about the Lucasville riots. And again, the inmates who were targeted in the Lucasville riots were basically categorized as cooperators or snitches. So
Yeah, but they were
it is a very real threat.
They were snitches inside of the
individuals who
prison.
come
They
into court
snitched on people
and
in the
testify
prison.
or-
That's not the same
Yes,
thing. Stop it.
All right. And on behalf of the defendant, either Mr.
And I know
Parker or
that
Mr. Nash, do you
I
want
mean, they do have, I suppose,
Argue
somewhat
concerning
compelling argument,
what your
but I
position
feel
is
like
about
a little
whether
bit the state is arguing
if we
against
film,
Jake being
videotape,
videotaped
photograph,
and whatnot,
record,
because quite frankly,
Mr.
they want his
Wagner,
cooperation. They need his cooperation.
that could somehow affect or may affect the fairness of the case.
Judge, I think,
Jake's testimony is Jake's
Hey, Judge.
testimony, period. He's
I
can't
hate
get
to
up there and
interrupt.
lie.
Can we take a 5-minute recess?
Yes. All right. Yes, we can do that. So we'll come back in just a moment, but we're in recess for 5 minutes. Thank you.
Can we have a quick sidebar? Can we approach and then decide if I can,
Well, I think she may call.
never mind. I would drop.
Put on hold.
I want to get,
Yeah, we're recent.
I want to get, I should, okay, maybe I'll take some more rest. Because I think that you're politically wise.
Let me let me go over to the long crime chat and see what they're saying over there about this situation. So while we, I'm just gonna mute this a little bit or turn it down. So while we wait for whatever the hell it is that they're doing, let me see what this is. Everybody was all blurry. So while we wait for that, I went over to, because I'm keeping an eye that the jury now has the case against Darrell Brooks. They're back in court this morning. I think there is, okay, so last night, let me recap for anybody that missed it. So what happened last night is after the judge was finished reading the jury instructions, right, of it, then she sent the case back to the jury, and there became this issue that she wanted to address. And what happened was it was discovered that there was a post made on Reddit of somebody claiming that they were a juror, and I forget what the post read. I'll have to go back and look it up. But anyway, that was, of course, obviously, if you have a juror who is discussing the case in any capacity on any social, hey, support with Steffa, good to see you, babe, on any social media, anywhere in the media, it doesn't matter, right? It's an issue, and it is juror misconduct potentially if it's true, right? And it causes a mistrial. let's let's switch over to that real quick so we can hear what's going on, because there's a little bit of a kerfuffle about that, and I want you guys to be able to hear it while we're on recess. See, your girl has got you covered. Give me just un momentito to share the screen. I really need to get on to Mac. I don't know if you guys can hear that in the background, but what he is doing is trying to he's getting in and out of the blinds, and it's driving me nuts because I know there's going to be at least 5 of the blinds broken back there. He drives me nuts. All right. Let me add this to the screen.
As you know, because of my status here in the jail, I'm allowed to have law library time up until a certain point of the evening, and then I have to shut it down per jail policy. So I was able to find a few different things that I wanted to bring to Your Honor's attention, if I may.
Go ahead.
One being United States versus Perez, 22 U.S. 579. And
no phone, who
that
dis?
specifically, I think it's referenced, because that one is pretty old in itself, but it's referenced in a lot of the other case laws that I actually found. I think, and I could be, if I'm interpreting this incorrectly, I apologize. They kind of use that as kind of like the benchmark for what they refer to as manifest necessity. That's kind of like one of the leading cases that each one references.
All right, so that's what's going on there.
In regards to issues similar to things like this when it comes into play. And it's specifically
but they're back in
points
court,
to
so
trial judge's discretion. And
let me share this one. Let's go back to Pike. Hold on, I gotta hide the chat.
This room has been, in my time, in the short time I've been here, full of meetings. You have not, to state the obvious, closed this court. So the fundamental constitutional interests have been vindicated. You have then, complying with C12C2, allowed witnesses like Jake Wagner to say no broadcast. And what Gear did to Plain Dealer is it said among those three fundamental tests, it said this court does have to determine if there's a reasonable and substantial basis to believe that photographing, in that case, the son's face, the juvenile, could harm him or endanger the fairness of the adjudication. That to me is critical because on the face of the Plain Dealer case, the only concern was the fairness of the proceeding in general. What Gear acknowledges is you now and should also consider any harm to Jake Wagner. And I think that ties in everything else I said a moment ago about my concern if the rules of the game are changed midstream.
Since you raised Gear, let me just say that I've read that case too. And I think they stepped out of the Rule 12C2. The judge stepped out of that in ruling that they could not photograph the juvenile's face anywhere in the courtroom, not just when he was a witness. When we step out of the language of 12C2, my reading has always been this. When you step out of that, then you get into the necessity of a hearing and so forth. Now, that has been my reading. Right now, the 4th District Court of Appeals has this order, and I think I'm bound by it, so that's what we're doing. But my reading has been that we get into this if we're not in a 12C2 situation. But that decision is on down the line somewhere, either when they decide to petition on the merits or the Supreme Court decides something. Yes.
Judge, if I could just add one other comment. In our previous motion, memorandum of law, we cited the clear case law that the media has no constitutional right to electronically record or broadcast proceedings.
Yeah.
And the law is clear on it. And federal courts, for example, it just doesn't happen because there's no constitutional right. And so, Ohio has elected this special rule to enforce the rulemakers believe is a fair process. So we just ask the court to continue.
This is the record. I would request that Mr. Wilson be able to put on one of the members of the STAR team, just so there is evidence in the hearings. I suppose the court could take judicial notice of the things that have been said here as far as people who cooperate with the state are not popular in prisons, and in fact,
There's evidence that you wish to put on?
If the court needs to hear testimony to make this decision, again, I think we can stand by what Mr. Meyer said, what we've said up to this point, that the fact that switching midstream again creates a potential confrontation clause issue that we don't want to deal with on appeal. So we can stand by that. If the court would like to bolster the record, we certainly could call a witness. So we need a second to make sure that they understand that they're allowed to testify through their headquarters.
Let me ask, Mr. Griner, do you have anything else you wish to put on today?
Do I have evidence?
Anything else you wish to put on today?
Well, I'd just like to respond.
Yeah.
Your Honor, I think, clearly, as you said, you're bound by this order. So I've heard some argument, I feel like, that goes to the order itself. The order gives respondent, and I suppose other interested parties time to respond. But the fact of the matter is we're not here to argue the merits of this order. This order stands, and as you say, you're bound by it. So, right, wrong, or indifferent, the order is in place. And this order provides that there are as you know, the three factors that go into it. Witness safety, inmate safety is not one of those factors. Now, you've taken that and said, yeah, but how does the inmate safety affect the fairness of the trial? But again, what we've really heard is at most speculation about that.
Thank you.
Prosecution has said, let's just not even take the chance. Well, that's not a reasonable and substantial basis
You
for
are
believing that public access could harm. He's also indicated that there is heightened danger whenever a witness cooperates. So the inmates, whoever he's going to be a danger with, they know he cooperated. They know he testified. Recording it, allowing the public to see and be part of this process, which is why
He's already
Rule 12
essentially in
exists,
prison, a snitch.
does not change that. There's no,
Thank you.
there's no indication that there's more marginal danger if it's recorded in some form or fashion.
Thank you.
In terms of, will the witness nervousness affect them? The witness takes an oath, like every witness takes an oath, that they'll tell the truth, the whole truth, and nothing but the truth. And that oath applies whether that testimony is recorded or not recorded. Trials are recorded and broadcast throughout the state of Ohio every day.
All day.
And there's simply no indication, no evidence that recording a witness's testimony somehow impacts the fairness of the trial. We've heard speculation to that effect this morning. We've heard no evidence. Thank you, Your Honor.
Thank you.
Mr. Wilson is,
Yes, Your Honor, I would request to put on one of the members of, the employees of the ODRC to provide testimony, just for purposes of the record.
Kidding? Are you really doing this?
And I would
Remember?
suggest
You're
this
trying
court
to
also,
really
there's
make an
a
emotional
vast
plea.
difference
That's what
between
this is.
somebody's name
This
being
ain't a
out in
factual
public
plea.
and their
This is
face being out in
emotional
public.
plea.
And again, videos that they can watch,
Bruh.
in perpetuity, frankly. And obviously, there's some chilling effect on the witness's testimony, otherwise we would not have witnesses opt out, right? Obviously, there's some level of discomfort, and it's not speculation to suggest that would affect their testimony. And certainly, again, the previous
states
argument
don't
that
have the opt-out.
changing midstream would raise the issue of the right of confrontation.
I will
so our
permit the witness
prisoners,
to testify.
listen, and
There's
let me
some
just
of
say
the
this
testify.
too. The truth of the matter is, other states don't have opt-outs, and there are transfers of prisoners all the time. So essentially, what the argument is that anybody that ever testifies and has their testimony recorded when they're testifying against a co-defendant then is in jeopardy. That is a complete poppycock. The truth of the matter is, just as the media attorney stated, Jake was a snitch even before he testified. That's the truth. What he says on the stand, whether it's recorded or not, doesn't make him any more or any less of a snitch by prison standards. The end. And that's the truth.
Do you solemnly swear or affirm?
Well, let's hear what you have to
About to
say.
give to the truth, the whole truth, and nothing but the truth, as you shall answer unto God.
I do.
You may be seated.
I'm not calling Jake a snitch. I'm saying that that's how the prison regards him, and they've
Mr. Wilson,
already
you may
said this
examine.
repeatedly. They basically called
Can
him
you
a
give the
snitch
judge
without
your name,
calling him a
please?
snitch.
Robert Horton, Horton.
Mr. Horton, where do you work?
Chillicothe Correctional Institution.
Okay.
Oh,
And how long have you worked at Chillicothe?
19 years.
Okay. Can you, if you could, take the judge through, when you first got hired on at DRC, was there a training process or training period that you had to go through?
Yes.
Okay. Tell the judge very briefly about that, please.
It's quite extensive. Classroom. At the time, there was physical fitness, all the legal aspects, rules and fractions for the offenders, and your firearms qualifications.
Okay. As part of that initial training, do you learn about security concerns with respect to inmates who are housed at DRC facilities?
Absolutely.
And not only security concerns with respect to staff, but do you learn about potential security concerns with respect to the inmates themselves? What may make them a target for certain things?
Yes.
Okay.
okay.
And did you successfully
Hold on, let me
complete
look this up.
all of your training there at
I think
DRC?
Yes.
that prison name
Once
sounds
you successfully
very
completed
familiar to me,
that,
so
what was
please
your
hold.
first assignment with DRC?
as a correction officer at Chillicothe Correctional.
Very briefly, can you tell the judge what your duties were as a corrections officer? What kind of stuff did you do there at Chillicothe when you first were assigned?
Standard assignments in housing units, making security rounds, performing searches of inmate property, searching for major and minor contraband, and ensuring the safety and well-being of the offenders as well as staff.
And again, in your duties there as a correction officer, with respect to ensuring the safety of inmates, was one of the things that you were looking out for at all times, potential threats to those inmates?
Yes.
Okay. In your time there at DRC, as a correctional officer at Chillicothe, working in the unit, were there times where you saw inmates attacked?
Yes.
And were there times where you saw inmates threatened?
Yes.
And were there times where you saw inmates injured?
Yes.
In your time there at DRC,
Oh, it's a
have
different
you seen
Chillicothe.
inmates
Gypsy Rose was in
threatened,
Chillicothe, too.
attacked,
He also
and
testified
injured
against,
because they testified
what's his name?
against
Nicholas
other inmates?
Woodjohn.
Yes.
Is that a common reason why fights or attacks happen with respect to inmates at DRC?
It can be.
Okay. Is the fact that a witness, or excuse me, that inmate testified as a witness against another inmate or another defendant or in a case, is that a factor that is considered in the security assessment with respect to an inmate?
Absolutely.
Have you, in your time there at DRC, gone on to other types of duty or specialty duties?
Special operations with the special response team and the STAR team.
Can you tell the judge briefly what the special operations team is and what kind of stuff you do?
With the SRT, their primary function is to respond to disturbances within an institution, or if there has been an influx of violence or major contraband found in various areas of the prison, we will go in, conduct a clear out, and attempt to get the major contraband and or homemade weapons from that unit for the safety and security of staff as well as offenders.
In your 19 years at DRC and in your time on special operations, responding to some of those violent incidents, did you learn or did you come to learn that some of those incidents or acts of violence were retaliation for an inmate testifying in a criminal case against a defendant or another inmate?
Yes.
In your time there at DRC, have you learned through observation, training, your general knowledge and experience, have you become accustomed with the culture of inmates within the facility? How inmates view each other, how they interact with each other, and the general culture of the different, I'd say, pods or institutions themselves?
Yes.
Can you tell the judge, with respect to the culture of prison and DRC institutions, how are inmates who testify against either co-defendants or other defendants in a criminal case, how are they looked at by other inmates generally?
It would be an uncommon term of tattletale, testifying against a co-defendant. It's not looked at well upon the other offenders in general.
Okay, and is that expanded even further than just the inmate that they, or just the defendant that they testified against?
Yes.
Okay, based on your knowledge, your training, your experience, when somebody testifies in a criminal case against another defendant or another inmate, does that word make its way amongst the inmates?
Yes, it does.
Okay. And again, does that, the fact that that information is spread throughout the prison, does that create security concerns for that inmate, staff, and other folks at the prison?
Absolutely.
In your time there at DRC, have you heard inmates who testify about other inmates referred to as snitches?
Yes, it's unprofessional. However, I have heard it.
And again, are snitches, are people who are labeled snitches within the
I'll be right
prison
back,
system
guys.
at risk
I'm gonna
for violence?
be in chat
Or
though, so y'all.
are they a security concern?
Be
Yes.
right back.
Have you heard terms amongst inmates or amongst the prison culture? Have you heard the phrase snitches get stitches?
I have heard that term.
And again, does that refer to retaliation against inmates who testify against co-defendants and other people?
Let the
Yes,
record
and
reflect
or
that I too have
other
no
offenders
special, and although I have no
going to
special
security
training,
staff
education,
about other
or
offenders.
experience relative to prison systems, I have also heard
With
term,
respect
snitches get
to-
stitches. All right, I'll be back for reals.
inmates who have family members in the prison system. The fact that you have inmates who have other have other family members who are also in prison, does that create security issues that DRC has to address?
Yes.
And what measures do you take with respect to that?
If there are co-defendants, the department makes its highest priority in separating those family members or co-defendants in other institutions around the state.
Based on your knowledge, your training, your experience, 19 years in this business, is it your opinion that an inmate who testifies against their brother in a criminal case would be at a higher security risk and potentially subject to violence for doing that, or retaliation for doing that?
Absolutely.
In addition to just the inmate being at risk, would it put DRC staff at risk for having to deal with it?
Yes.
Another.
All right, let me ask defense, do you wish to ask any questions of the witness cross-examined?
No.
Mr. Griner, do you wish to cross-examine the witness?
Mr. Horton, are you familiar with Jake Wagner? Are you aware that Jake Wagner entered a plea in this proceeding?
Yes, sir.
And when was that?
I'm not sure the date.
Months ago?
Perhaps.
And it's been publicized that part of that plea agreement was that he would be testifying against his brother, right?
Yes, sir.
So that's been well known, right?
Yes.
Is the DRC's efforts typically effective in dealing with enhanced security risk? I mean, you guys know what you're doing, don't you?
Absolutely.
Okay, thank you.
Any redirect?
In spite of your best efforts and the security that you have in DRC, do inmates still get injured and killed as a result of retaliation for this type of stuff?
They can.
And staff as well?
Yes.
No.
All right. Any further questions, Mr. Griner? Any further questions from the defense? Is there anything else to be submitted in this matter?
No, Your Honor.
Mr. Griner? Anything further?
No, Your Honor.
All right. I'm going to find with respect to Jacob Edward Wagner, Edward Jacob Wagner only, that there does exist a reasonable and substantial basis for believing that public access could harm or endanger the fairness of the adjudication, that the potential for harm outweighs the benefits of public access, and that there's no reasonable alternative to restricting the filming, videotaping, recording, and photographing of that witness while he is a witness, while he is testifying, and therefore we'll order that not be done. I'm not making that a general order with respect to all witnesses who choose not to be filmed, videotaped, recorded, or photographed. We'll take that on a witness-by-witness basis unless we hear otherwise from either the Court of Appeals or Supreme Court concerning this issue. I'm also going to just put in an order that that anyone who is in the courtroom prior to the court opening a court session, that would just not be at the start of the day, but the start of each recess, after each recess. Anybody who's in the courtroom will be permitted to stay as long as they are seated at that time when the court opens the courtroom, or immediately do become seated after they've complied with the directive to please stand. Then they must be seated. And if they're in here, they'll be allowed to stay. I think that's what we've been doing anyway, but that was an issue that somebody had mentioned at some point. Also, if media, and this applies to media only, need to leave the courtroom in order to respond to something that's directly related to their job. It was mentioned if we are not videotaping, recording, photographing, or filming, if they need to leave or come back in, I guess I should say, for that reason, that it's not being filmed, et cetera, then they'll be permitted to do that as long as they will be seated in the back so that we're not, and they're not distracting the jury. And we will have to regulate that sort of on an incident by incident basis. There just will be no general rule that they be excluded. However, my bailiff here and other people that work for the court as bailiffs are able to inform me, if I don't see it myself, of people who are abusing the privilege by coming in, going out, coming in, going out. I don't think that's going to happen. I'm not anticipating it. I haven't seen it yet, but if it should happen, then we may have to, on an incident by incident basis, exclude someone. I don't want that to happen, but but we're dealing with professional people here. They should be able to understand the appropriate behavior, and I haven't seen, with one exception, I haven't seen inappropriate behavior out of the media. So, and I don't expect to. I don't know if that addresses everything that you mentioned.
No, that's fine, Your Honor. With respect to the ruling about Mr. Wagner, I guess I would ask, because the third factor is no less restrictive means, I would ask, could there be audio only of his testimony as a less restrictive means?
Well, I'm not going to order that in his case. I think that, as somebody points out, that's sort of changing the rules midstream. And frankly, fairness of the proceeding and having a fair trial for both sides is a paramount duty of the court. And I am concerned at this point, he's been advised that he wouldn't be videotaped, et cetera. And I think in fairness, if we change that, we would have to notify him in some way, shape, or form. And I'm just concerned that could affect the testimony in some way. And I know that counsel for the defense is very sensitive to that issue, and therefore I'm just not going to order. In his case solely, he's not to be filmed, videotaped, recorded, or photographed. Now, is there anything further we need to put on this record?
Your Honor, we've been informed again today that there's recording happening while we are not on the record. So before the court opens session and on breaks. And I know the court has advised the media previously not to do that. It seems we have to continuously.
We're talking about the camera in the back?
Yes, audio too.
All right.
Yeah.
That is part, I think that's fairly standard. That is a part of the court's rule. There's people discussing matters of they may be court-related matters, they may be not court-related matters, but the thing that, I would assume that what the media is interested in is what happens in our court hearings, not and not otherwise. I don't know, Mr. Griner, if you want to be heard on that or not. I think it's just a situation where the camera is turned on early and it's not turned off during a break or something of that. Sometimes, I don't know how often it happens, but it has been brought to the court's attention.
Yeah, Your Honor, I would just say that, counsel needs to be able to have private conversations, and this is not a situation where somebody in the audience can
I
hear.
understand the importance of it. I was just wondering if Mr. Griner had something.
I don't have anything to add.
All right. And so, and we just try to remind, and I would remind counsel here and the bailiff and everybody else that we need to make sure that the one operating the camera is aware of that rule every day. And although it gets, you've heard me admonish the jury every single day of the same thing to the point where they could probably recite it back to me. Well, we need to just inform the camera person every day, the new camera person, just tell them what the rule is. I don't think we'll have any trouble with that, as long as they understand what the rule is. So let's do that. If somebody would intentionally not do what they're supposed to do, bring it to the attention of the court. And I would say to the media the same thing. If there's something that you feel.
Okay, so what I had said before we went on break or before I went outside was that I would like the record to reflect that, as I have no experience, training, or education in the prison system. I too have heard the phrase snitches get stitches. I think, quite honestly, I understand why the judge ruled the way that he did. I don't find, quite frankly, though, that either the state or the prosecution made a compelling argument in this situation as far as the safety of one Edward Jacob Wagner. And the reason that I feel that way is because, quite honestly, the truth of the matter is this: Jake pled. Those proceedings were aired. It was part of the plea deal months ago, okay, that he would be required to testify against both his brother and his father. So that has been known. Okay, that is a known, that was known and has been known. The court appears to be on break. However, what we can do is we can rewind and see what happened this morning. Let's see what happened this morning. Hold on a second. I'm gonna rewind. But the bottom line is, frankly, that is a ridiculous. It's. I understand the argument being made, but I don't find that argument compelling. I don't find that his safety is any more at risk now than than 2 days ago when he first began testifying. That's just the truth. I just don't find that to be a compelling argument. However, I do understand the judge not wanting to change the rules midstream. However, yesterday, this was basically the situation all day yesterday, was this verdict that was handed down by a higher court than this judge. And after lunch yesterday, this judge allowed Mr. Wagner to again retake the stand and continue testifying, knowing that there was going to be a hearing today. And I don't understand, quite honestly, why he did that. And that's the truth. So anyway, let's get over to Mr. Brooks and see what he is up to. I'm disappointed in this. What I'm hoping is that this is what I think is going to happen next. At some point, the way that I understood the testimony and the schedule, as it were, okay, this was when this article came out, this hearing was not on the table, okay. Today in this courtroom, this matter has been this was an appellate court's decision, which is a higher court, right? So this specific matter respective to the media and Wagner and stuff was already on the table, but obviously the media is not going to write about something that is being decided, right? Okay, because there's nothing to tell. They don't know what's happening. So this is what the schedule was supposed to be. So Jake was supposed to testify. It was suspected that it would be probably 2 days worth of direct testimony and probably, I don't know, he's a special case as far as cross-examination goes, but the defense has had really short, frankly, cross-examinations, but we'll say in total, between direct, cross, and any rebuttal, 3 days. Okay. Then there was going to be audio played from the 2018 intercept wiretaps. And then it was supposed to be Angela Wagner. So we should probably be able to get to hear some testimony. Well, it won't be tomorrow because Thursday there is no court, but probably Friday. And then there will probably be another hearing because Angela Wagner has also opted out. And I suspect that they're going to make the same argument that her safety is a risk. And I think that the judge is going to rule probably the same with respect to her. So we won't hear Angela's testimony either. So yeah, anyway, let me put Brooks on so we can see what what's going on with him. All right.
Thank you. And sir, for your appearance this morning.
Just 1 second, I was sorry, not thinking here. I'm not sure if I even have everything.
I will say that Mr. Brooks is
I apologize for that.
so far, his tone and demeanor is
All right.
more appropriate.
You're ready.
I'm here as third-party intervener in that matter, appearing as authorized representative for my client. I'll set for value in return for value all of the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and make a reservation of all of my constitutional rights, mostly the First, the Sixth, and the 14th Amendments.
Thank you. The record to reflect that the individual known to this court as Darrell Brooks is present in custody in person. He is wearing his jail attire this morning. I do want to make a record that at 8:46 p.m. yesterday, I did swear in 2 additional sheriff's deputies who would be working with our jurors through the overnight or third shift hours. I did administer the same oath that was administered to all the other bailiffs yesterday evening. Then, of course, we are open and the jurors are here and they will be instructed to start their deliberations. The only other thing I would put on the record is I have received information regarding the Reddit post that there was a subsequent post from that website indicating that it was a prank. And so I don't know to what extent the sheriff's department is looking into that as well, but it's my understanding based on news reports that that entire post or site was taken down. Not the site of Reddit, but it's no longer, I believe, viewable. But there was that additional information regarding that, at least from the administrator, I believe, of that post. So I just wanted to put that on the record. And if and when, or I should say when, the investigation is completed, I will assure the parties that you will be provided with that information.
So,
Go ahead.
so it's being called a prank.
Per the Reddit post itself, yes.
So we don't have any idea if that's a fact though, right?
You're correct. I'm just putting on the record the additional information that's been reported on. And then again, once the sheriff's department concludes their investigation, it will be turned over to the parties. So at this point, until there's a question or a verdict, courtroom will remain open.
I
I'm going
agree.
to be
He
working
does
in my
probably
office
realize
on
the
other
end.
things,
Yeah.
and will be available, of course, if there are any questions or if a verdict is reached.
I have a-
So notify the parties.
Judge,
Yes,
oh, go ahead.
Oh,
go ahead.
I'm still very concerned about this whole Reddit thing after having the chance to fully read it and look at some of the language that's in it. It's very concerning.
Uh-huh.
That's why there's an investigation, sir. It's anytime there's an allegation that the integrity of this judicial process has been compromised, especially with a juror, I take that incredibly seriously, which is why I turned it over to the sheriff's department.
I would like Your Honor to, if it pleases the court and if it pleases Your Honor, I would like to look at some alternatives. If I may bring up the in regards to the language, I also want to state that for the record, this did not come about from the prosecution side, from the defensive side, and certainly not from Your Honor's side. This is something that just pretty much sprang up. A lot of my concern, though, just not from just the language in the actual post, but I was kind of concerned that I was the last one to learn of this information. It had been known. I wasn't aware of it until after 6:30 last night, or around that time, because I don't want to misquote the record, but somewhere around that time.
It was shortly after 7.
Oh, so it was after. I didn't know. I thought it was. I knew it was after 6:30, but I didn't want to incorrectly state the record. Your
I can
Honor,
address that for you right now if you would like.
yeah, if it pleases you, Your Honor, I would like to request some alternatives to this issue.
What's your specific request?
My specific request would be to look into a mistrial and also any alternatives along those lines, short of that or along those lines, or a mistrial. I was looking at some, obviously, yesterday was very, very long for everybody.
Mainly due to your
And
shenanigans.
as you know, because of my status here in the jail, I'm allowed to have law library time up until a certain point of the evening, and then I have to shut it down per jail policy. So I was able to find a few different things that I wanted to bring to Your Honor's attention, if I may.
Go ahead.
one being United States versus Perez, 22 US 579, and that specifically, I think it's
he's going to
referenced
appeal, but
because that one is pretty old in
I don't
itself,
know that he
but it's
actually
referenced in a lot of the
has
other
any
uh,
merit to his
case
appeals.
laws that
I don't know.
actually
If they're
found.
written
I
by
think,
him, they're probably not going to have
and I
any
could
merit.
be, if I'm interpreting this incorrectly, I apologize. They kind of use that as kind of like the benchmark for what the
Let me say it again because I just thought about that. So here's the deal. He can appeal. No, even if you represent yourself, you absolutely have the right to appeal. Everybody has the right to appeal. I mean, not well, okay, let me take that back. Not everybody has the right to appeal. But if you go to trial and you have the right to appeal. Like Chris Watts does not have the right to appeal because he took a plea deal. So his circumstances, his only the only remedy available to somebody like Watts was going to be the 35C. However, Mr. Watts is not under the rules and of a 35C. Mr. Watts does not qualify for a 35C unless it is brand new, never before heard, seen, etc. evidence. It could not have been available at the time of the plea deal. That's not considered new evidence. So yes, Mr. Brooks can, let me pause him because I want to hear what he has to say. He can appeal. However, it depends on, again, what he appeals on, okay, and how that appeal is written. Because appeals are very specific and require very specific language, and just there's a lot of rules. And then and also unlike a trial, excuse me, during the appeals process, the burden of proof is 100% wholly on the appellate, so the defendant. Okay, they're the ones with the burden of proof, and it's usually pretty high. And that's just the truth. That's the way the appeals process goes. So he can appeal, but like I said, I don't know. I don't know that it depends on, again, of course, what he would appeal on, but he has a little bit of knowledge about court proceedings and the law, but appeals are very, very complicated. And so I think that it's just my personal opinion that if he were to author the appeals himself, I don't think that they would honestly be successful, quite frankly, because he doesn't have enough legal knowledge to be effective as his own counsel in an appeals process. But yeah, he can appeal. All right, here we go.
that speaks of potential for an impartial verdict. Specifically, it says along the lines of impartial verdict, if an impartial verdict can be reached, or if a verdict of conviction could be reached but would have to be reversed on appeal due to an obvious procedural error in the trial. That's one of the main issues that speaks to.
Mm-hmm.
I also looked at Arizona versus Washington, 434 US 497, and that speaks to what I was stating before. It says neither party in a case has a right to have his case decided by a jury, which may be tainted by bias. And I say that because it certainly wasn't anything dealing with the prosecution. They had nothing to do with this. The defense had nothing to do with this, and certainly you, Your Honor, had nothing to do with this. But just for the concern factor, the language, it's pretty clear that this, if not directly.
Oh, you're
came
welcome,
from a juror who
Kezchick.
sits on this panel, it came from someone who sits in this courtroom every single day. The language,
Let me just stop you right there, Mr. Brooks. Do you know how many people are sitting in this courtroom every single day? Let me just go and look really quick at the Law and Crime channel, who is currently broadcasting this as I speak. All right, I'm going to look them up right now. There are 91,000 people in the Law and Crime chat, live chat, streaming these proceedings. 91,000 people. Okay. So those people have been sitting essentially remotely, but in this courtroom every single day. So that is poppycock. But I'm going to let you continue because I'm going to look up this Reddit post because it's been removed, but you know the media got it. So, and if we have to, guess what else we'll do? We will go to last night's stream. We will rewind it because I know approximately the timestamp. I'll find it for you guys. Don't you worry. And we will go over specifically and implicitly what the Reddit post read.
it directed towards you, Your Honor, directed towards having clear bias towards the defense. Some of the things that they quoted of having knowledge of is extremely concerning. Extremely concerning. And then going back to some of these case laws that I cited, it talks about something to the effect of the ends of public justice. But I think that is leaning more so towards the judge's discretion, I would say, at least from how I was interpreting it. Obviously, I'm not educated in a lot of the laws in itself, but how I was interpreting it, this is definitely a concerning issue. It's definitely something that I would request Your Honor to take a long look at. Look at some options, look at some alternatives. And those case laws I cited talks specifically about that, options that you, Your Honor, can look at and use your discretion to see if it's appropriate in any way. But I'm extremely concerned about this. If anything, for cautionary reasons, I believe, Your Honor, that you definitely should take a look at everything I'm saying here in these case laws and
What's the request, though, that you're making based upon the case law that you cite? I heard in there mistrial, but I want to make sure I understand your request for relief and what it is.
You say request for
Relief.
relief.
Like, what are you asking me to do based upon the information that the limited information we have about the Reddit post and this trial?
I guess my request would be, because of the concern of this, to look at a mistrial, or at the very least a discharge of the jury at this time, so this can be resolved. This is alarming to say the least. This post, and I don't know what Reddit is, to be honest. I've never heard of it or used it, so I don't know the extent of. It's almost like this could be like a snowball type of thing. It can start with something that's this small, and then it can snowball out of control into something totally different. I don't know the extent of this website. I don't know who. Well, I think the name of the person who sent the to who alerted the clerk, of course, to this post. I think his name is in the email. But then that even begs the question of how did this person come across this site? What is their significance to this? What is their role in this? It's just so many questions, and I mean, clearly this points at the court's integrity. It points at your integrity, Your Honor. It's alarming. It's very alarming. And if there's a chance that there can be hidden bias in this jury, it needs to be addressed now rather than later.
Let me stop you right there, Mr. Brooks, because I found it. The post has been deleted, but there are screenshots, and I'm going to let you continue until we get to the point where it's at the recess, and then I'm going to read it to you guys, and then you tell me what you think. Okay?
This is very concerning.
Well, thank you for bringing up your concerns. Let me turn to the state if they want to respond, and then see what other issues they want to cover this morning.
Judge, the original post was on a subreddit thread called Justice for Darrell. That's the copy that the defendant has in front of him. That post was edited last night, claiming that it was a prank from the start and that the original poster didn't think it would get that far out of hand. The way that Reddit works, the only person who can modify the content of the original post is the original poster. And because the jurors have no access to any electronic devices, I think it's safe to say that our 12 jurors back there are not the original poster. So I think that puts that issue pretty much to bed. It's still obviously under investigation because the court takes it so seriously, but there really is no actionable or any real reason why we should doubt the jury's being unbiased in this case.
I object to that on the grounds, Your Honor, that, like you just stated, it's an investigation going on. And if there's an investigation, then that clearly says that something is amiss.
Well, no.
We have 15. We have 15 jurors.
No, it doesn't mean that something is amiss. What it means is there's a potential that something is amiss, and they're going to look into it. That's what that means, sir.
I don't think anything's put to bed because we don't know. It's unfair to say that the issue was put to bed when there's still so many questions left out there. I'm sure you reviewed it yourself, Your Honor. You see the language in this, whatever it is, thread. I don't know. I don't know what this is. It's clearly a post from somebody who has intimate knowledge of the trial and what's going on in the trial. I don't think. I mean, common sense would tell you that this is someone who's very close to the case, whether they were intending to be funny, whether they were intending to try to prank the court or anything like that. We don't know. That could be anybody's guess. The language in this, the way that it's formatted, they lay out 4 specific points of what they think. they point to certain language in the case. They make references to saying when we were in the room, they got certain feelings from when where they specifically refer to themselves and a group. That would be we, plural.
I've heard people refer to themselves as we. That doesn't, I mean, it's incorrect, but it happens.
They say,
They don't say, they wrote.
and I have to admit, I am biased against the defendant for the horrible acts he did. And they attack you, Your Honor. They clearly attack you. This is if this is someone's idea of fun, is anybody's guess, but I don't believe that it is, clearly by the way it's formatted and by the language that is in it.
Mm-hmm.
This is clearly someone with intimate knowledge of the case and what's going on. Clearly.
Okay.
There's no other way to interpret this.
Oh, really? Okay.
You can tell by what they're laying out in the language that they're speaking with.
They're not
If
speaking,
this is clearly
they
someone
wrote.
close to the case. And
Stop saying that.
because
You're
of
driving me
that, it
nuts.
still has to be, I'm informed of the investigation, but there's still too many questions left in the air just from this. How can we say anything's put to bed when there's still an investigation?
5, 6,
For all
7,
we know,
8.
what if this turns up that it was someone on the jury, or what if it turns out
What if cars run on spit? What if
that more
monkeys fly
people
out
are
my
involved
butt?
in it than just whoever this anonymous person was who left the post? It's too many questions and it's too concerning. What if something like this springs up again at the last minute? We've been going through the trial now for basically 3 weeks, the better part of 3 weeks. And even in court days leading up to the trial, we've never had anything like this happen. Nothing like this has been brought to your attention. Nothing like this has been brought before the court's attention. This just came out of the blue, and now all of a sudden it's being labeled a prank. Is that because they were found out?
Oh my
I
God.
mean, it begs so many questions. It's too uncertain. It's too concerning, and it's too alarming. It's too alarming to just overlook and say, "Oh well, we'll just set it to the side and let them." No, this there has to be some type of alternatives, and something has to be done. Something.
It's being
And
investigated.
if that's a
Something's being
mistrial,
done.
if that's
Bless it.
discharging a jury, if that's some other type of alternatives that can be looked at, I'm sure that these case law speaks to other options that could come into play. They deserve to at least be looked at.
They are being looked at. That's
If
what the
anything, to protect the
investigation
integrity
means.
of the trial. I find it very hard to
Bless
believe
it. I
that this
can't.
close to the trial being over, and all of a sudden these issues are being raised. So
Ain't
this
that
is
some shit, ain't it?
obviously not a prank.
Oh, it's
And
obvious
it's
now.
obvious
Gotcha.
that this is someone with intimate knowledge.
Mm-hmm.
It's very clear to me.
Okay. It's very clear
Let me
to
address your
you.
concerns, sir. I cannot make conclusions at this point about whether this is legitimate or prank. What I know is as follows. I received the information about the subreddit post at approximately 9:30, 9:40 yesterday morning. I alone made the decision to withhold advising the parties because of where we were at in the trial, because there was nothing in that post. It was an anonymous post that would lend credibility to that it was in fact one of these jurors. But out of an abundance of caution, I referred it to law enforcement because it is very serious if the integrity of these proceedings were to be put at issue by a juror. I'd remind you though, every single day these jurors were read the bulk of jury instruction 50. They all took an oath, and I have no reason to doubt that they would violate that oath at this time. So I took and I made the decision to withhold telling the parties because we were in the middle of instructing the jury. I was in the middle of instructing the jury. And I wasn't going to delay the proceedings because it was so speculative at that point and remains speculative at this point. As you know, the case went to the jury. I brought this up. I waited about a half an hour once the case went to the jury. Frankly, we had had a long day. I wanted to get a bit to eat, and then I wanted to come back out and make a record of what I had. Once again, the forensic unit with the sheriff's department has taken lead of this investigation. I'm not a part of that investigation. Law enforcement will handle it. From my perspective, not only did the clerk of court's office receive emails regarding this, it sounds like the district attorney received emails. I may have even gotten one. I don't remember the time. It was later regarding the post. Frankly, people figure out my email all the time. It was not solicited by me in any way, and I did not respond to it. And I simply forwarded that email on to law enforcement. So it's pretty clear to me that a lot of people have access to Reddit. I personally am not a user of Reddit, so I don't know the ins and outs of it, other than it is a social media site where people can create accounts and post, and there can be like chat rooms, for example, or just various, as this is called, subreddits. And at this point, you've requested a mistrial. You've requested that I discharge the jury. I'm declining to do that at this time, sir. Again, I need to make decisions based upon the record that's before me. And right now, the record is speculative. There are no facts to support a mistrial or discharging the jury. I trust the parties will continue in their own independent investigations, that you will continue reviewing case law, make whatever requests that you deem appropriate. I certainly will take time to look at the cases you have cited to see if there's anything based upon the requests that you have made that I would need to further review. But at this time, I do not see grounds for a mistrial. I do not see grounds to discharge the jury. And that is how I will address it at this point. I know the state, I believe, wanted to address something else. I'm not sure if that was it, but you had deferred to Mr. Brooks. So go ahead. Is there anything you want me to address or at least bring to the court's attention at this time?
Just a minor point, Your Honor. You had noted the defendant is in his orange jail uniform today. It's my understanding the jail did offer him the ability to put on his street clothes, and he declined. So I just wanted that on the record. There may be occasions where this jury has to be brought into the courtroom for one reason or another, and he should be in civilian clothes if that occurs, if he chooses to.
It's a good point to bring up. It is possible the jury would need to be brought out if there is any question that I need to answer on the record. If for some reason the technology were not to be working appropriately when videos or other evidence are displayed to them. And so it is possible that the jury would need to come out. Of course, they'll come out if and when a verdict is reached. So I would certainly give you the opportunity, sir, if you want to change into the street clothes, that I would certainly direct the sheriff's department to make that available for you.
No, I
should you
missed
choose.
that. M5, 6,
Isn't it
7,
my
8.
choice?
Yes, it is.
So why
It
do
just-
why do I need to be in street clothes? Why does that need to be on the record? That
Your choice
if-
should be
if
placed on
or-
the record. sir.
if or
That's
if
why.
not, I was offered to be in street clothes. If I made it the choice,
Do you dispute that, sir?
yes, I dispute it because it's my choice.
Well, no.
At
Do
this
you
point-
dispute that you were
at this
given
point,
the
there's
choice
no-
this morning?
At this point, there's no reason why that should be on the record. That if I was not offered street clothes, what relevancy does that have to?
Hold on a minute.
Could have potential relevancy later on if
All right. Let me explain to you, Mr. Brooks, and then we'll see how correct I am, what relevance this has. So I can't cite, because I'm not an attorney, the specific case law that this comes from, but it has been decided long ago that it is prejudicial to the jury to see a defendant in jail clothes. So it was decided long ago that the defendant would be permitted to wear street clothes because at the time of trial you are, and because your verdict hasn't been read, you're innocent until proven guilty, and that it's prejudicial to the jury to see a defendant wearing jail attire because they think that the person is automatically guilty. That is why the choice was given to you, and the fact that you declined to change your outfit of the day, sir, must be noted so that it is on record that none of your rights to a fair trial have been violated. That's why it's important. That's why it's noted. There you go. Let's see what the judge says.
You were to challenge that and claim that you were required to wear your jail uniform or jail attire. You're not required. This is a trial. You have the right to wear street clothes, and I will certainly provide that opportunity should you wish to change at any point in time. But what you're telling me is it's your choice to be in jail attire. I'll respect that choice, of course.
So why does that need to be stated for the record?
I just indicated why, sir. So
I don't see the relevancy of it.
all right, at this point, unless there are any further issues, I am going to go back into my office. The courtroom will remain open, and we'll let you know when the jury communicates with us, either about a question or verdicts.
There is something that needs to be addressed, subject matter jurisdiction.
Oh my God.
Why hasn't it been proven on the record yet?
Okay. So I'm going to speed this up just in case something has happened, but I'm going to mute. And I'm going to read to you all the post that started all of this. Okay. First, let me read you the article. All right. About what occurred. All right. Well, no, I guess I don't really need to read the article because we just listened to what happened. So let me just read what was written. All right. It is called the account that authored this post is called Justice the Number 4 Darrell. It reads, I am a member of the jury on this case. Here are my thoughts on the trial and on this subreddit. So to start with, I obviously shouldn't be here. I am not allowed to look stuff up about this trial or really have any connection with the internet, but nobody actually follows sequestering rules anyway. Hence, I am obviously posting anonymously. I accidentally wandered into here a few days ago from the subreddit drama thread on my main Reddit account. Here is my opinion on the trial. First off, I think it's pretty obvious due to chain of custody that the defendant is in fact Mr. Brooks and he did it. However, I've had throughout this trial doubts about various aspects of the case. 1. The judge is clearly biased against Mr. Brooks. I got that feeling from when we were in the room, and my eyes have been open to how she acted towards him when the jury was out of the room. Clearly, she is not an impartial judge and has been trying to belittle, demean, bully, and pull procedural tricks on him fairly frequently. I had my doubts already, but the subreddit has shown it to me clearly. Hold on, let me click next. And then I have to scroll. Very rude. Oh, bless it. Okay. 2. Mr. Brooks has clearly not been given the chance to plead his case in court. He has been silenced and mocked at almost every turn. While he may be a bit loud or crass at times, I still believe his side deserves to be heard. 3. I do have significant doubts about subject matter jurisdiction. I didn't understand it when discussed in court because the defendant was repeatedly silenced. But I do understand now, thanks to this sub, and I agree that subject matter jurisdiction is a great concern here. 4. This subreddit has made me aware of jury nullification, and I am grateful for that. Overall, I am not sure what I will decide. I am not educated in law, and I have to admit I'm biased against the defendant for the horrible acts he did. However, it is also clear that this trial is a complete kangaroo court. Mr. Brooks has not been allowed to try and prove his innocence, subject matter jurisdiction, or explain the circumstances surrounding the events. Hold on, let me go to the next. Um, Mr. Brooks has not been allowed to try and prove his innocence, subject matter jurisdiction, or explain the circumstances surrounding the events. It's hard to imagine what could justify it, but we just can't know because of his trial. Because of this trial, I think is what it says, because it's cut blocked because of an arrow. Do better on this website. For these reasons, I'm torn between locking him up and throwing away the key or jury nullification. Both have arguments for and against them, and I'm not looking forward to choosing. I'm mostly writing this to help myself process my thoughts on this, but please let me know what you think. Then there's a comment after it, and it's a mod, and their handle is Black Justice Forever. And it reads, the user has submitted proof that he is a juror on this case for reasons of anonymity and the integrity of this trial. We will not disclose details on this process, but we are confident, and it stops. Confident the, I know, and I can't, it doesn't let me make it read anymore. Hold on a second. Then the Reddit post was later edited to read, quote, this was all a prank. I didn't think this would blow up like this. We are sorry. Love our drama. Love, comma, our drama. So there you go. Frankly, he wants the juror. Okay, first of all, let's start here. If this is an actual juror and it can be verified, blah blah blah, all the things that must take place, then obviously that is a real concern and a real issue, and it is evidence of real jury misconduct. And should that be the case, the truth of the matter is, and I stand behind this, when when you are picked for a trial and you're sat as a juror, you do take an oath, and that oath is very serious, and it should be taken seriously and has real consequences if violated. So, hey Heather, whatever. So if it can be proven through an investigation that this is an actual juror, then obviously it's juror misconduct, and there should be a mistrial, and that's just the truth, because we do want fair and impartial jurors. Okay, that's part of the rights, and regardless of whether I or personally believe in Mr. Brooks' guilt or innocence, the truth of the matter is I respect the legal process, our justice system, and I will argue for the rules to be followed and all of that, right? Okay. But the other thing is, I don't think that Mr. Brooks's argument for it being concerning is not, I mean, it is obviously concerning, but it is being looked into. And so at this point, there's really nothing to do but wait until the investigation has reached its conclusion. And I also find it interesting that Mr. Brooks is saying that it has to be somebody with intimate knowledge of this case, of this trial. Sir, incorrect. it doesn't have to be somebody that's literally inside that courtroom. Okay? Because quite frankly, this court, these proceedings have been broadcasted worldwide. Everybody who has internet access has access to YouTube's. So they also have access to the Law and Crime Network, which means that which is the and Court TV for that matter, which is who's streaming this trial. Period. The end. So honestly, it doesn't. I couldn't understand his argument about it seeming as if the post was negative towards him when in fact the post is actually positive towards him, and negative almost in the exact same sentence, because the juror allegedly, the author of the post, let me just put it that way, the author of the post is admitting bias against Mr. Brooks while simultaneously saying he didn't get a fair trial. So it's an interesting dichotomy um, in that post itself. But at this point, the truth of the matter is, nothing can be done until an investigation is complete. And I'm curious, though. I'm actually more curious about the investigation because the only way to verify that it is not somebody on the jury, right, is for Reddit to turn over the information that is collected through their site, like with an IP address. And well, he doesn't have access to electronics either, so I don't think that he authored that. To be quite honest with you, the way that the post is authored, this person has a level of intelligence and good command over the English language and quite frankly syntax and the way and sentence structure. Um, to be blunt, I find when Mr. Brooks speaks, quite honestly, it's an attempt to sound intelligent, and he does have some level of intelligence. He's not, doesn't have diminished capacity or anything like that, but quite frequently he uses words. He either mispronounces words wholly or he uses words completely incorrectly. Exhibity being one of them. So there you go. And I mean, it's possible, Heather, whatever, that look, in high profile cases, okay, there is an element of the population that idolize these people. We've seen it with Bundy, we've seen it with Richard Ramirez, we've seen it with Dahmer. I mean, for Pete's sake, there were women writing to Dahmer and sending him money in prison knowing he's gay. They don't have a chance with him. And so there is an element in the population that just idolizes people like this. I think I'm more inclined to believe, quite frankly, that it is exactly what the author said it is. It was a prank, horrible prank, a completely irresponsible prank. But what I'm really concerned about, or what I'm really not concerned, interested in, is how Reddit will handle the subpoena to turn over the information they collect on their users. Because I don't participate in Reddit, so I don't know what their privacy policy is. So I would be very curious. because I've been thinking about this with like respect to YouTube as well. So, what happens when you have two YouTube creators who are beefing? And oh, they'll find it. They'll find the source, Heather, whatever. It'll happen. I'm just curious how long it's going to take and how cooperative Reddit will be. But for argument's sake, you have two creators who are beefing, okay? And the beef escalates to doxing, and I'm talking about the illegal kind of doxing, okay? Not how people use it on here where they say, well, you said I have a username and you gave out my government name. That is doxing, but that's not that part is it's frowned upon on YouTube because of etiquette, but that part's not illegal. I'm talking about when um, records are shown, like it is public information. Your address and stuff like that is public information. However, if that public information, which contains private information, sensitive information, is posted publicly on a third party like YouTube, Facebook, Reddit, Twitter, that kind of thing, with the intent to bully, harass, threaten, extort, yada yada yada, then it becomes illegal. And what I'm curious about is when if that were to happen, well, it has happened, but if legal proceedings were started, um, and the subpoena came from, if they were not criminal proceedings but civil, because it's different with criminal, if they were civil proceedings, how YouTube would handle, who is owned by Google and has very very um, strict what they use your information and privacy policies. They're very pro keeping your information private, your private information private. So I'm very curious how how Google, YouTube would handle that. I'm very curious about it. Because as you guys know, and I've said this many, many times, what tends to happen is that social media companies are more reactive than proactive. So they're not going to do anything until they're made to do something, which is, we've seen it with Facebook and how they handle bullying and stuff like that, and it took a long time. And then we have laws, obviously, right? But the laws are now catching up to technology. And then we have, as Mr. Brooks has brought up repeatedly, subject matter jurisdiction. Who has jurisdiction over these criminal and civil cases, right? Is the court who has jurisdiction the state in which the crime was committed, if it's criminal, right? Or where the victim lives. Likewise with civil proceedings. Who has subject matter jurisdiction? Is it the court in which the petitioner resides, or the court where the respondent resides? So all of these, situations and questions are going to have to be addressed, and they will be addressed. I'm just curious. I like to see it because I'm always fascinated by legalities and trials, etc. So I do want to stop sharing this. Just right. Let me see scooch it forward a little bit and see what's going on. All right. I'm going to stop sharing this one. And then I'm going to pop over to the Pike County trial and see what's going on over there. And if we can't hear or see anything, then I'm just going to go ahead and end the stream. But don't you worry. I got you covered. I am going to be watching both trials, and if we get a verdict today, I will most definitely um, let's see. Hold on a second. It looks like they might be at recess. So I don't know what's going on. Anyway, so I think what I'm going to do is go ahead and end it. And as soon as I know anything, I'll definitely cover it. I'm absolutely gonna go live tonight. Well, let me think about this. If there is a verdict, I'll definitely go live tonight. If we get to a point in the Pike County trial that there is testimony, of course, I will go live tonight. However, I really want to. I've got to work a little bit more on this um, Dahmer episode that I'm working on for Thursday, because I absolutely 100% no if and buts about it will be premiering that Thursday night at 9 o'clock Eastern, PM Eastern. And I want it to be good for you guys. And so, because I'm not going to, like, I'm just going to premiere it, and then I'll be in the chat. I like it better that way. And then depending on how you guys receive it and how it goes and whatnot, maybe I'll have like a live and we can discuss it later or after the premiere if you guys want. It's up to you guys. But anyway, that's my plan. What? Lynn? Let me go back. Thank goodness you came in and spoke up, babe. Thank you so much. Holy guacamole. Let me go. Hold on. Oh, bless it, Jen Lu. Learn how to type, ma'am. Don't be getting 30 minutes, eh? Let's see. All right. Yes, correct. 37 minutes. Oh my gosh. Thank you so much, Lynn, for letting me know that. Bruh, what am I doing? Hold on a second. All right. It's like my first day on StreamYard again. Thank you. Thank you so much, Lynn. Lynn is going to be our. Thank you, Heather. Thank you so much. I appreciate that. I need to make us a little song, for when you guys do memberships or when you give me super chats. I so, so, so appreciate it. Thank you so much. Lynn, you are going to be our good noodle for the day. That is a SpongeBob reference. That's what Mrs. Puff calls her students in her little driver's ed class. Good noodles. Lynn has won our good noodle for the day. Let me go ahead and okay. How long did they deliberate? I don't know what time they went home yesterday, but I did say, oh, thank you, Kez Chick. I appreciate that. Thank you so much. I appreciate that. I did say that I thought that we would have a verdict. What did I say? I said at lunch, tomorrow at lunch, I believe. I'll have to go back and check. But let me share the screen. All right. For you guys. Hold on just 1 second. All right, let me get away from the live chat, hide chat, make this bigger. I'm sure you like hearing my step-by-step everything that I am doing. Yeah, I said that they would deliberate, and I thought we would. Is that what I said? Oh, maybe you're right. You probably are right. I am glad we get to see this together. I. Oh, okay. So let me think about this. Um. Oh no. I'm so sorry, Heather, but I'm glad that the other dog owner reimbursed you for your vet bills. I hope your pupster's okay. That is so scurry. Well, they definitely deliberated more than 1 hour because shit, they've been there since 9. That's, uh, you know. All right. Well, we're about to know. I'm going to mute, but I'm going to be in chat because honestly, you guys, I need a cigarette. I'm not going to lie. Let me just make sure. I don't know why this is doing this. It's very annoying. Let me turn the volume up. Really, YouTube? How are you going to play me? All right. Go back over here. I'm going to mute. I'm going to be in chat. I'm going to go have a cig and get something to drink. I don't know if you guys can hear it, but my voice feels so raspy. I'm quite parched. All right. I'll be right back. And Heather, just so you know, babe, I'm so glad that they reimbursed you, and I hope that your puppeteer is okay. And I get it. I understand about bills, like and adulting and stuff like that. And you don't ever have to worry about being a member. Or I'm just everybody that comes in the chat and is supportive. I'm grateful for membership or not. So. Oh, bless his heart. His fat layers saved his lungs. Oh, bless his heart. Oh, well, I'm glad he's okay, Heather. All right, I'm going to mute for reals for reals. I'll be right back. I'll be in chat, though, so y'all have to behave because I can still see y'all. Whew, okay. So while I was outside, I got a notification that I got a comment. So of course I went and read it because I had a chance to. And I want to also, while I'm thinking about it, you know what? I'm not even going to address that comment because it is what it is. Uh, apparently I cuss too much, but they took the time to listen and to tell me thumbs down, and it is some constructive criticism. So for that, I appreciate it. I will work on my potty mouth. All right, hold on. I want to address and 5678. Let me just go to the studio because I saw your comment, babe, and I want to talk about that just really quick. All right. Thank you for letting me know. She says, "Hi, my fave, Jen Lu. It was reported on another channel that it was a juror that was crying. Just thought I'd let you know." Thank you so much for letting me know. I absolutely appreciate that. I try to be um, on top of things as much as I can, but sometimes, I can't be everywhere. I'm not omnipotent, but um, if you guys, because I know yesterday was an incredibly long day of just long day period, and with court and everything. So what happened yesterday is during the closing arguments, the prosecution played a video, and it was not broadcast, so the audience could not hear the um the video, but the audio was not turned down in the courtroom. And so I'm actually thinking that there was no audio to oh wait, that's not true. The picture wasn't broadcast, but the audio to the video was broadcast. And so what obviously the audio was on in the courtroom as well. And there was audible crying. And so, and we were all like, when we heard it, we were all like, oh my gosh, somebody is crying. And to know that it was a juror, wow, that's sad, obviously. Um, thank you, Kes Chick. Yes, the thumbs up does help the algorithm. And you know what else helps the algorithm? Even the thumbs down I got. They commented, I'm just like, they commented on the roast and said they can't take my channel seriously because of too much cussing. And they wrote in all caps thumbs down, which is fine. They took the time to listen, they took the time to comment, and I appreciate that. It is constructive criticism because I probably do cuss too much. Um, but I would like to also say that it is a roast and it isn't intended to be serious. So you don't have to take, I mean, I'm glad that you didn't take the roast seriously because it wasn't intended to be serious. But thank you for your comment. And I will work on my potty mouth. That's all I can do. I feel awful for the family that had to sit and watch that again. Um, I can't imagine. Um, and I hope I never have to imagine. And I hope you guys never have to go through any of that. And it's awful. You don't have to be careful, Heather, whatever. I will say this. There are times, so, okay, anytime and I can't speak to anybody else's situation, I can only speak to mine because it's the one I know for sure, for sure. So anytime I do a live on true crime, even when I did the Halloween Ends live, I guess it's because my channel, the way that it's set, is that it's not set for kids. So and it is a true crime channel that's like 90% of my content. Well, it's really more like 95% of my content is actual true crime. The rest of it has been like scary movies and stuff like that, because that's also a passion of mine. But most of the time when I turn monetization on, I will immediately get the limited ads. I will say that 90% of the time when I have it reviewed, I get no restrictions. So it's available to all advertisers. But I do know that when you request a manual review, not only does YouTube review the actual live itself as far as what you show, what you say, etc., they do look at the chat, and they can make a decision on limited ads based on what's in the chat. So I don't, the fact of the matter is that I get most of the time it gets the limited ads gets taken off, which tells me that um, whatever cussing may or may not be in the chat is limited and hardly at all, and it's not even enough for YouTube to raise a fuss. So I say we leave our chat the way it is. If it ever becomes an issue, you guys know I'll talk to you about it. It's, it is what it is. It's not really that deep. I think it's funny that it was a roast and they said they can't take my channel seriously, but they took the time. So it is what it is, It is what it is. We have about, let me go look. Let me turn the chat on and see. Hold on a second. I think the pinned post says 11:45. So yeah, not much longer, you guys, not much longer. The other thing I wanted to talk to you guys about just while we're, waiting for this. Oh, let me fix this. While we're waiting for this trial or this verdict is, as of late, I have been very interested in the Quentin Simon case, mainly because I want to express to people that I am equally frustrated with the situation and all of that. And but at the end of the day, I want the right person arrested for the right crime, and more than that, I want to see justice for Quentin, and I want to see the person or persons responsible brought to justice, and I'd like it to be a clear path to conviction. Um, so I understand why law enforcement has taken the approach that they have taken. It's really not, it's law enforcement working with the DA also, as far as the arrest goes. And I understand why they're doing it. However, I also think at this point, for me personally, I was on Melissa Jade's panel last night, and quite frankly, it was a fantastic live. I thought that there was some great, really good discussion had over there, and um, if you guys get an opportunity to check it out, um, I I would encourage you guys to do so. But anyway, one of the things that I sort of came to the conclusion of last night was that we really don't know a whole lot of facts uh, with respect to the circumstances of this case. Law enforcement has, and rightly so, been really, really tight-lipped about it, and that is to protect the integrity of the investigation, and that should be respected. And it made me think about the situation that we are currently in with the Daybell Vallow trial, where the judge has decided that there has been so much media coverage about this case. And then after Lori and Chad were arrested and charged with the unaliving, and then we've had all of these pretrial hearings, and the pretrial hearings have been streamed, that it has tainted the jury pool further. And so that's why the judge decided, okay, no more cameras in the courtroom. I think he will change his mind when it's time for the trial to start, but right now I think he is exercising an abundance of caution and recognizing that we don't want to taint the jury pool further. It's already going to be difficult to get a fair and unbiased jury. And so I understand that decision. And I was thinking about that last night when I was on Melissa Jade's panel, that I don't want I don't want there to be that same issue with Quentin's case going forward. And so for me, I will still continue to follow the case. And if and when there are updates and new information from law enforcement or other verifiable sources, I will report on that. But I think for now, for me anyway, I'm going to take a step back from getting on panels and talking about the case, because right, like I said, we really don't have any new information at this point. And when that changes, if and when that changes, then my stance will change. But for now, I think that anything that we do moving forward with discussing the case is going to be speculation. And I don't want to, there's only so much of that can be done. And for me personally, I think I've speculated as much as I'm willing to speculate, and I'm good. So that's going to be my stance on the Quentin Simon case. I will, of course, follow it and pay attention and stuff, but I think I'm going to, be just be quiet more. Do you know what I mean? Like, I'm not going to get on panels and stuff like that, because until there's something new, I just think that's what feels right for me. I've what are Kez? Oh, Chick Tracy and Kez Chick. You guys are so silly. I just really do think we have like the coolest, chillest chat in all of the YouTube streets. I really do. I think, you know, I need to get Chicken Lady. I need to get a hold of her and get an update on my namesake Hen Lu and see how she is doing. I hope she has not lost any of her feistiness, but I also at the same time hope that she isn't giving Chicken Lady too much trouble, because bless her heart, every time Chicken Lady makes a little video for me to show me some stuff that Hen Lu is up to. Hen Lu is acting a fool and giving Chicken Lady a hard time, bless her heart. So, yeah, Hen Lu is just was absolutely named appropriately. Hen Lu does what Hen Lu wants to do when she wants to do it, and that's it. Hen Lu gives no F's. So, yeah. I think it's so cute that Hen Lu is oh that she's named appropriately. Her behavior definitely matches her name for sure. So yeah, I like that. Oh my gosh, this feels like forever. We're 10 minutes away and it feels like forever. Let me while we're waiting, I'm going to go over and oh, Oh, Chick Tracy. Mm-mm-mm. Tisk, tisk. Let me go over to Law and Crime and see what's going on with Mr. Wagner. Oh, hold on a minute. Let me see if I can hear. Hold on. Let me put my earbud in. Ah. Let's see what's going on over there. Okay, still no audio. They are filming, but they're only filming um, Special Prosecutor Canepa. So I like her skirt. I will say that. All right, let me get back over to my channel so I can monitor you heathens in the chat. Can you imagine? You guys are so great. I hardly ever have to monitor you guys. Only time I ever have to monitor the chat is when the bots come in and drop their ridiculous links. Hot girls for you in U-Town. Oh dear. Kez Chick and Chick Tracy. Y'all play nice. I don't want to have to pull your card. This is your warning. And if you guys keep it up, you're going to have to pull your card from green and change it to yellow. Did you call her a tart? A tart. So, when we were home, we every year we go to my husband's grandmother's house for Thanksgiving, and I don't Thanksgiving, like the meal was over and we were all just kind of sitting around talking, and I cannot remember what the context of the conversation was or why Granny busted out with, well, she's a hussy. And y'all, just to hear her say it's first of all, I wasn't prepared to hear it come out of Granny's mouth, but that undid me. And then the way that she said it, the way she said, oh, she's a hussy. It was just so stinking cute that I couldn't contain myself. So it just cracked me up. Okay. Utter Nutter, is this typical for them? Oh, how cute, Heather, whatever. That's cute. That's cute. I'm curious if when the verdict is read, because when they read it, it's going to be something to the effect of, in the case number blah 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 blah, Wisconsin versus Darrell E. Brooks Jr. Yada yada yada. I wonder if he's gonna stand up and be like, "That's not my name. That's not my name." You guys think he will? I think he will. I do. I think he's going to be like, objection. That's not my name. They call me her. They call me Stacy. 5 minutes until court resumes, which means we should be getting audio shortly. No, he gonna be big mad. Well, depending on what the verdict is. Depending on what the verdict is, I'm very curious. Obviously, that's why we're all here. But yeah, let's see what happens. I really feel like, you guys, that I have truly, truly found my little niche in the YouTubes with covering these trials. I really do. First of all, you guys know how much, obviously, I love true crime. Otherwise, I wouldn't cover it at all, period, right? And at the same time, I really enjoy the trial part of it. And I have to tell you guys, this morning when we were listening to the hearing over there in the Pike County trial, and the attorney for representing the media was making his arguments, that's what I love. I love a good back and forth between lawyers. And I when he was questioning the witness, for, the media was, and I thought he asked pertinent and excellent questions. I mean, quite frankly, they were the questions I had. And then I have to give it to the state for their rebuttal question. That was good. They did a good job. So that's, and I really do enjoy when justice is served. And I am it's really, really important to me. I respect our justice system, and it's very, very important to me to have a fair trial. And it's very important to me that the right person be on trial for the crime of which they are accused. So I will stand up for people that I believe are like actually innocent. I'm not gonna like
Record and state versus Brooks
Uh-oh.
appearances are as they were before. I would make just one note that Mr. Brooks is now present in a suit. And I will also advise that at 9:43 a.m. this morning, I was advised that the jury had reached verdicts in this matter. And without anything further, I'll have the jury brought out.
Here we go.
Your Honor, I don't consent to being called that name and would like to address subject matter jurisdiction for the record as yet to be proven.
Your objections are noted. I will not be addressing subject matter jurisdiction. Please bring the jury out.
Would it be proven for the record, Your Honor?
Just a reminder to everyone that I do expect everyone in the courtroom to demonstrate appropriate decorum and courtesy as the verdicts are read and refrain from audible responses. Any disruptions may result in removal from the courtroom.
Hey, Cement Shoes. Hey, I haven't gotten an email from you yet on the little bit on
Your
the
Honor,
information
tacit agreement
that you
not to address
have
subject matter jurisdiction for the record.
for the first episode of
Jury's
the
coming in.
Dahmer
All rise, please.
case.
I respectfully
I'm so
object to
curious
ruling,
about
Your
that.
Honor, and request the legal reconsideration of your ruling for the record.
Your requests are noted, sir. We will not be addressing that further.
For the record, may I respectfully reject that ruling and take exception to that ruling, Your Honor. Is that a tacit agreement and a judicial determination that you don't have to answer that question as a public servant, Your Honor?
Oh, for Pete's sake, are we really back on this bullshit again, sir? You know what,
For the
Utter
record,
Nutter,
may I
I actually
request
think that might
the
be
legal or factual
accurate.
basis for
I
your
don't
ruling,
think,
Your Honor?
even though the jury was given the case last night, I don't know that they actually deliberated
Might be a
last
false
night.
alarm.
For the
So
record,
that
may I
seems
respectfully
probably
request a
right.
written judicial finding of fact and conclusion of law on this issue, Your Honor?
All your requests are noted for the record. They all are denied, sir. All rise. Jury's coming in.
For the record, may I respectfully move for an interlocutory declaratory appeal on this matter, Your Honor?
Denied.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction?
Denied.
Based on what law or fact, Your Honor?
Yes, please, cement shoes, babe, because I'm
Is
going
that
to
a
be
tacit
working.
agreement that you don't have
Bless
to answer
it.
that question? For the record, Your Honor, as a public servant?
I said an hour, which, but because I am the creator of the channel, I obviously can't win. That's
Will not be addressing any
that's
of those.
cockamamie, and I would never do that. So, Chick Tracy,
Thank you,
you
everyone.
are the
Please
winner.
be seated.
But yeah, babe, cement shoes, will you please
Ladies and
email me
gentlemen
that?
of the
Because I'm
jury,
working
Becky Pick
on
or
the
the Mundy be the foreperson.
thing. I'm working on the episode after I get done with
Your number
all
11.
this.
Have you
So I
reached
appreciate it.
our counsel?
Thanks.
Yes.
All right, would you
Ah!
to the bailiff?
Sorry. Oh my gosh. Are you kidding me? Stop doing that. Oh gosh. Kez and Chick Tracy have both won because I don't want to. They've been back and forth taunting each other in the chat all morning, and I don't. So you girls win. Chick Tracy. Oh, bless it.
Your Honor, seeing is that we've reached a verdict, is it necessary that I have these shock devices on my ankles?
Yeah, I'm glad that this is done and over with for the time being. Let the victims and their families begin to heal. And I want to give a special shout out to a listener who's listening but not in chat, to my other half, Dr. B. I'm so proud of you. Congratulations. Love you. I'm just so proud of you, babe. I can't even tell you. I'm so proud of you and happy for you. Corky, I was thinking the same thing because I was like, but I now this has opened up another rabbit hole for you, girl. Hey, Shamita, good to see you, babe. Now I'm going to have to Google and find out under what circumstances can shocks be employed, because now I'm curious. Heather, whatever. For the record, I believe they deliberated.
76
Oh, wait.
signed verdicts
Sorry.
and 76 unsigned verdicts.
The verdicts are
Would
unanimous.
be what I would expect. Right, I will read each one into the record. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 1 of the information, dated this 26th day of October 2022, signed by the foreperson, juror number 11. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 2 of the information. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. Hey, you are to be removed right now. You will not do that. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 3 of the information. And I should state as to count 2, it was signed and dated by the foreperson, same as to count 3. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 4 of the information, dated this 26th day of October 2022, signed by the foreperson.
Vernon,
Did the
hold on.
defendant commit first-degree
I'll tell you in
intentional
a
homicide
second,
while
Amelia.
using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 5 of the information,
Thanks,
dated
babe.
today's date and signed by the foreperson. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 6 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 7 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 8 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 9 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 10 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 11 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 12 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 13 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 14 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 15 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 16 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant guilty of first degree recklessly endangering safety as charged in count 17 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 18 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 19 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 20 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks,
Usually they
guilty
do
of first
know
degree
what's
recklessly
going
endangering
on in this
safety
situation.
as charged in count 21 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree
agree.
recklessly endangering
Should be
safety
made
while
to
using
stand.
a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 22 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 23 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree, recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks,
'Cause she's
guilty of
standing.
first degree, recklessly endangering safety as charged in count 24 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree, recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree, recklessly endangering safety as charged in count 25 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree, recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree, recklessly endangering safety as charged in count 26 of the information, dated today.
Amelia, they give him the option and he decided to. They can't make him wear street clothes or, but it's up
The
to him.
jury find the defendant, Darrell E. Brooks, guilty of first degree, recklessly endangering safety as charged in count 27 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree, recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree, recklessly endangering safety as charged in count 28 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree, recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree, recklessly endangering safety.
Cement Shoes, you're hilarious, and I hope you never change.
Dated today's date, signed by the foreperson. Did the defendant commit first degree, recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree, recklessly endangering safety as charged in count 30 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree, recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree, recklessly endangering safety as charged in count 31 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree, recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree, recklessly endangering safety as charged in count 32 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree, recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree, recklessly endangering safety as charged in count 33 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree, recklessly endangering safety while using a dangerous weapon? Answer,
No, Kezchik, he has like shock thingies on his ankles.
for the information, dated today's date, signed by the foreperson. Did the defendant commit first degree, recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree, recklessly endangering safety as charged in count 35 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree, recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree, recklessly endangering safety as charged in count 36 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree, recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 37 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 38 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 39 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 40 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 41 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 42 of the information. Dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 43 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 44 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks,
Hey, birthday
guilty
cakes.
of first degree recklessly endangering safety as charged in count 45 of the information. Dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 46 of the information. Dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 47 of the information. Dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 48 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 49 of the information. Dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant,
I have to mute just for a second, but I have the whole, subtitles on because fair use, and I agree. Um, I'm very curious to see his reaction. I'm a little shocked he's being quiet, but I have a feeling that has to do with what's around his ankles, and we'll see.
Recklessly endangering safety as charged in count 51 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 52 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 53 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 54 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 55 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 56 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 57 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 58 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 59 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 60 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 61 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 62 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering
Hey,
safety
Tony,
or
good to
using
see
a
you, babe.
dangerous weapon? Answer, yes.
Oh my God, stop doing that.
We the jury find the defendant, Darrell E. Brooks, guilty
Oh my
of endangering safety
God.
as charged in count 63 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 64 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 65 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 66 of the information.
Yes, 76 counts, Heather.
Did the defendant
Oh,
first degree
stop doing
recklessly
that.
endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 67 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 68 of the information. Did the accident involve death to Virginia Sorensen? Answer, yes. Dated today's date and signed by the foreperson. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 69 of the information, dated today's date and signed by the foreperson. Did the accident involve death to Leanna Owen? Answer, yes. We, the jury, find the defendant,
I can't take
Darrell E.
this.
Brooks,
I have to fix it. I'm
guilty
sorry, you
of hit
guys.
and run as charged in count 70 of the information, dated today's date and signed by the foreperson. Did the accident involve death to Tamara Durand? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 71 of the information, dated today's date and signed by the foreperson. Did the accident involve death to Jane Kulik? Answer, yes.
I don't think that's right. M5678, it's
We, the
actually
jury,
the
find
letter
the defendant,
E.
Darrell E. Brooks, guilty
I
of
don't
hit
know
and run
why
as
they're,
charged in count
it's
72
closed
of the
captioning.
information, dated today's date and signed by the foreperson. Did the accident involve death to Wilhelm Hospital? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 73 of the information, dated today's date and signed by the foreperson. Did the accident involve death to Jackson Sparks? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of bail jumping as charged in count 74 of the information, dated today's date and signed by the foreperson. We, the jury, find the defendant, Darrell E. Brooks, guilty of bail jumping as charged in count 75 of the information, dated today's date and signed by the foreperson. We, the jury, find the defendant, Darrell E. Brooks, guilty of battery as charged in count 76 of the information dated today's date and signed by the foreperson. Mr. Brooks, would you like me to poll the jury?
Yes.
Members of the jury, I'm going to ask each one of you individually to stand up, identify your number for the record, and then state whether the verdicts read in open court are your true verdicts. I'll start with the foreperson. And I'll read your numbers first, so it's a little bit easier. So juror number 11. Were the verdicts read in open court, or are the verdicts, let me rephrase that. The verdicts read in open court, are those your true verdicts?
Yes,
Thank you.
and
Juror
5,
number
6, 7, 8, they are.
The verdicts read in open court, are those your true verdicts? Yes. Thank you. Juror number 6. The verdicts read in open court, are those your true verdicts?
It is.
Thank you. Juror number 14. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 19. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 27. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 34. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 41. The verdicts read in open court, are those your true verdicts? Yes. Thank you. Juror number 45. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 46. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 48. The verdicts read in open court, are those your true verdicts?
They are, Your Honor.
Thank you. Juror number 51. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. I should state for the record, I did have the alternates brought back in. Obviously, they did not deliberate, but it was important to have them because there are certain instructions I give at the end. All right, Mr. Brooks, are you satisfied with the polling of the jurors?
No.
I'm sorry?
No.
The court is so satisfied with the polling of the jurors. The court now accepts the verdicts. Ladies and gentlemen, on behalf of myself, the citizens of Waukesha County, and both parties here, I want to thank you for the time and attention that you've spent on this case. Your service in this case is now concluded. There is no requirement that you maintain secrecy concerning what happened in the jury room, but you do not have to discuss the case with anyone or answer any questions about it. On behalf, again, of the court and all of the parties, we thank you for your service over the last 3.5 weeks. You are discharged and free to go. All rise for the jury, please. Thank you. Be seated. Anything from the state at this time?
Your Honor, the state moves for judgment on the verdict as to each and every count.
Anything from you, Mr. Brooks?
What is judgment?
Given the verdicts from the jury here today, the court will enter judgments of conviction based upon the verdicts on all 76 counts. Court will also revoke bond. In this case, I plan on bringing the case in Monday.
Hang
This
on,
coming
Tony,
Monday,
and
the
I'll look it
31st
up.
at 1
I
p.m.
think he's
to
like
address further
41 or
scheduling.
42, but let me just
What I would
check.
ask the parties to do between now and then is to determine how long you think each side will need to present their sentencing remarks, whether you anticipate anyone speaking on your behalf. If so, how many, how long, so that I can then look at my calendar and adjust and make sure that I have the appropriate amount of time to do that. I'm not going to sentencing on Monday. It is just for further scheduling at 1 p.m. before my afternoon case.
Judge, would you be willing to consider persons appearing by Zoom for sentencing?
Yes, I would not do anything different than what I've been doing since we started utilizing Zoom, and that is to make it available for both victims and family members of the defendant if they so choose to make statements over Zoom.
Okay, thank you. That
You're welcome.
helps us in our planning.
All right. All right, then. Thank you, everyone. We are adjourned for
40.
today. We'll see you all on Monday.
He's 40. Hold on, let me turn this down. Hey, Momo. Tony, he's 40. Wow, I'm not surprised at the verdicts. I am a little shocked at Mr. Brooks' behavior. However, I am pleased that he conducted himself correctly. And I while I was looking that up, I sort of missed it. I think they said Monday is when they'll begin the procedure for sentencing. I think I mean I missed that part. I'll go back and listen to it. You guys don't worry about it. But wow. Wow. There's one other thing that I want to tell you guys before I get off of here. Give me just one momentito. So the Chatham County Police have made an update in the Quentin Simon case, and I would like to read that to you. It reads as follows. We are now 3 weeks into our search for Quentin Simon, and finding him, I think they meant his, finding his remains the top priority for the Chatham County Police Department. We are committed to giving Quentin the professional, detailed, and thorough investigation that he deserves. Thanks to the expertise of the FBI, who was on the ground with us within 3.5 hours of Quentin being reported missing, we have had the advantage of using every investigative and technological tool available. No expense has been spared, no work has been deemed too much or too difficult to undertake. The exhaustive search of the landfill where we believe Quentin's remains are located continues. As we told you last week, this is not a quick process. At the same time, our investigative case team is working diligently to put together every piece of evidence to determine the facts in this case. The search for Quentin has been the most massive undertaking ever for our department and has involved the work of well over 100 law enforcement and civilian personnel. We would like to thank the following agencies for their assistance with manpower, expertise, and equipment during the last 3 weeks. FBI, GBI, Chatham County Sheriff's Office, Savannah Police Department, Liberty County Sheriff's Office, Chatham Emergency Management Agency. So there you go. They're still working to find little Quentin, and they are continuing to investigate the case and the details surrounding it. So that is sad news that they still have not recovered him, but I am glad to hear that they are continuing behind the scenes. I think it was important given the interviews that took place on Tuesday. So there's your update on that. Like I said, depending on how it goes today in the Wagner trial, the hearing earlier this morning was obviously a delay in trial proceedings. So I'm not exactly sure if we will be able to hear or see anything today. I think Jake is going to take up the day. Quite frankly, I don't think, and then there's no court tomorrow. But should I be wrong? I will go live tonight, and I will go over and update that case or the trial on Thursday night. I have I'm going to premiere the first episode of my series on Dahmer's victims. But for now, I want to thank everybody for being here. I appreciate your support as always. It's a sad day in a lot of ways because the verdict is what I believe to be justice. However, unfortunately, it doesn't undo what was done November 21st of 2021, and it doesn't bring anybody back. So while it is a victory, it is a hollow victory. I hope that the victims and their families can begin to heal now from this. I can't imagine their loss. And with that, I think I'm going to leave you guys with the trailer for the Dahmer I can't even think, for the Dahmer series, and I will either see you guys tonight or tomorrow night. Take care, everybody. Hug your loved ones. Take care. Be safe out here on the real streets and on these YouTube streets, because they is dangerous. And I will talk to you all later. Bye.
After the second time, it seemed like the compulsion to do it was too strong, and I didn't even try to stop it after that. So no, race had nothing to do with it. It was just their looks. After